The Planning and Land Use Management Committee, they will allow about public hearing room. The General Honorable Councilman Design. We do anticipate Councilman Rizal to be joining us. We have quite a few items that are built up. As you can tell by the acoustics of this room, it's hard to understand what anyone is saying, even with a microphone. So if you do have a conversation, please take it outside. I'd just like to share with you some instructions as you come up to the microphone. Please give us your name and address. If you can speak into the microphone, we can hear you much more clearly. I know many of you have worked on very eloquent letters, but you will be given 2 minutes to make your statement. So try to get to your main point as quickly as possible. To facilitate this meeting, there are quite a few of you regarding one item, and if the person has made your statement or you agree with the person, it's okay to just make that statement, say, I agree with the previous speaker, and give us anything new or different to add, please. So that way we can limit the redundancy of people's messages. That being said, we do have a few items that we can go through, and I know there are some of you that have come distances to get to this meeting. Some of you have labored in getting your parking and just to get your place in this building. But there are some items that I have been told have been continued. And there are people that are here for that item. And out of respect to the fact that you took the time to get here, I'll ask if you still want to comment. But if you'd like to come back when the ordinance is being addressed, you're also welcome to do that. We do have 2 items that have police personnel with us in the audience. That's items 8 and 12. And I will cover those as soon as I go through the agenda to identify those items that have been continued. On item 1, we have quite a few cards here, but we've been asked by the council office to continue that item for 2 weeks. So item 1 will be continued for 2 weeks. I'm assuming the people that are here will want to come back in 2 weeks. Is there anyone that submitted a card that feels compelled to speak? If so, please raise your hand. This is for item 1. 1 person? 2 persons? 3? Then we'll just go through the agenda and we'll come back to you and let you speak since you made the trip over to City Hall. And that's for item number 1. It will be heard again when it comes back in 2 weeks. So again, you're welcome to come back in 2 weeks. So I'm trying to give you guys a hint. When you feel you're here, then that's fine as well. Okay. Item 2, we have cards as well, so we will be hearing that one. Quite a few cards, actually. Item 3, see no cards, we can adopt number 3. Number 4, we do have to call special, even though there are no cards. Number 5, we can move on that and we'll approve a seal recommendation to fund 8 historic preservation consultant services contracts in the amount of $1.8 million from the Construction Services Trust Fund for a period of 3 years. That's item number 5. 6, several cars will continue for 1 week. 7, single cars, we can move that on the consent calendar. 8, we'll call special. 9, 9, we have cards, we'll call special. We have no card on 7. It's a consent item. 9, we will call special. 10, we'll also call special, given a few cards we have. 11 will continue for 1 week to November 24th. 12 will call special. 13 will continue to January 5th. Scheduled for council January 19th. 14 will call special, given the cards we have. 15, the director is not here, so we will not be having the oral status from the director of planning. So that is the schedule for today. Let's start with number 8, Roberto. So we do have police officers on that item. Can you please read into the record case number 8?
Yes, Councilman. Item 8 is an appeal by the Claremont Corporation, and they're appealing the decision of the zoning administrator. This is a revocation case, and it's for Wally's Liquor in CD9.
Sorry. Okay, let's hear from the planning department.
Good afternoon. This is Sue Chang with the City Planning Department. This subject case is DIR 2007-0556RV. This subject application was initiated by the City of Los Angeles for nuisance abatement associated with a liquor store known as Wally's Liquor at 1953 South San Pedro Street. The liquor store has been at this location since 1980, and the current owners purchased the property and the business in year 2008. This site has been a source of nuisance activities for the last 10 to 25 years, but the problems have escalated in the last 2-3 years. The LAPD testified that the problems have been getting worse in the last year after the current business operators purchased the business in year 2008. The LAPD made 10 arrests associated with public drinking in 2008, which are directly related to this subject location. The nuisance problems on and around the subject property include, I'll give you just a few of the complaints I received during testimonies and my hearing, and LAPD officers will give you more details if you have further questions. Drinking in public in front of the subject liquor store, in the parking lot and adjacent sidewalks, homeless persons loitering, drunk persons passed out and lying down on the street, harassing and intimidating pedestrians, urination, defecation, panhandling in the parking lot and streets adjacent to the premises, violent crimes such as batteries, assault with deadly weapons. There are trash and debris of food containers and empty bottles of alcoholic beverages around the property. And also the Wally's Liquor Store had 2 illegal game machines on the site. There were coin-operated devices for gambling, which is illegal. There have been incidents of non-intoxicated persons buying alcoholic beverages for intoxicated persons at the store. This was observed by LAPD officers. The residents also complained that the security guard on the site hangs out with drinking persons and is not helpful to mitigate nuisance activities mentioned at the testimony at the hearing. The business operators also allow illegal vendors on the site selling foods, clothes, DVDs, and CDs. In order to mitigate adverse impacts, the zoning administrator, on behalf of the Director of Planning, imposed 27 operating conditions. The business operator agrees to comply with all the conditions imposed, except for condition number 3 and 13. Condition number 3 requires operating hours to be limited from 7 a.m. to 11 p.m. daily. The store currently open from 6 a.m. to 12 midnight, Sunday through Thursday, 6 a.m. to 2 a.m. Friday and Saturday. Condition number 13 requires a minimum of 1 security guard during operating hours, and then business operator feels that that will have financial impact on the business operator, and it may not be financially feasible. Actually, the LAPD recommended the security guard during, 24 hours, and I assume that because the store is not open 24 hours, I assume that they recommend security guard during operating hours. This site is surrounded by so many sensitive uses. All People's Christian Center at 822 East 20th Street. San Pedro Elementary School is at San Pedro and Washington Boulevard. Bus stop at southeast corner of San Pedro and 21st. Bus stop at 20th and San Pedro Street. This liquor store is en route to go all bus stops and all these sensitive uses. All People's Christian Center attracts 300 to 400 students and parents attendees daily to attend their program. The residents complain they cannot pass the street adjoining this liquor store because the people just lying down, drunken people harassing the residents, and little kids are so afraid to pass by this liquor store. These conditions are not onerous, and to present the viable operation of the business, the required operating hours and security guard conditions are the most effective mitigation measures to make this business in orderly manner. Therefore, staff recommends the denial of the appeal with the exception for condition number 27, that is condition for indemnification. The condition requires that this applicant defend the city in case we go into litigation. With advice from City Attorney's Office, condition number 27 is recommended to be deleted. That's the last condition on my decision letter. 27. The
That's
last
on
condition.
Page 26 on your report?
Page 7 of my determination letter.
Okay.
That's the last condition in my determination letter. That's the standard condition city requires for discretionary actions. Since this application is a little different, the City of LA is the applicant. With advice of a City Attorney's Office, staff recommends to delete the condition.
Okay.
I'll be available for your question, and LAPD officers are here to testify for you.
Any questions from my colleagues for our planning department staff? Ms. Chang? Okay, thank you, ma'am. Okay, only because of the urgency to have our officers out in the field, I'd like to call the officer first, then I'll ask for the appellant. Officer Michael Dix?
Yes, sir.
Good afternoon, sir.
Good afternoon. I'm Police Officer Michael Dickus. I work for the Los Angeles Police Department Detective Support and Vice Division. I'm testifying today on behalf of Newton Area Vice Unit, the Senior Lead Office, and the Police Department as a whole. As previously stated by the zoning administrator, this location has been a nuisance and a plague to the community for many years. That was stated by Officer Carrillo also at the zoning administrator hearing. I've recently reviewed the crime stats, the arrest reports, and the calls for service for this particular location, and it definitely supports the need for the conditional use permit as indicated by the zoning administrator. You will hear citizen complaints and testimony, I hope today. They did testify at the zoning hearing, which will also support the need for the CUP at this location. Within 4 or 5 block radius of this particular location, there's an elementary school, high school, and the church that was indicated by the ZA. They should be testifying upon the behalf of the police department also. These individuals walk their children to school every day, and they will indicate that there's individuals that are drunk, passed out, inebriated, and on occasion accosted these individuals while they walk the children to school. Over the last year, I've conducted various inspections of the location, the most recent being yesterday. The inspection I did yesterday was primarily to meet with the manager and security of the adjacent business, which is the King Taco. The King Taco shares a parking lot with the aforementioned property. While I was at the location, I did note that there was an individual that was drinking in public while we were there, and I thought that this was kind of irresponsible considering the fact that the applicant has a plum hearing, and the day before, an individual was drinking in public. While I was at the location, I met with the security guard who basically reiterated all that was stated by the zoning administrator. He has personally seen urination, drinking in public, 415 fights, gang activity. He also stated that the citizens are sometimes afraid to even patronize at the King Taco because of the individuals that are at the liquor store. He further stated that he's been employed by the King Taco restaurant or the property owner therefore, and to myself, I find that hard to believe that a restaurant will employ a security guard and the location that's causing the nuisance does not have one. Based upon what the zoning administrator had said in the testimony, I believe that this solidifies the need of a security guard at this location all hours of operation. I further want to state with the hours of operation, I think the applicant is appealing. There's testimony from the All People's Church that they have been at the location at as early as 6 to 7 o'clock in the morning, and people have been passed out for the location, which will lead a common person to believe that those individuals purchased the alcohol, drank all night, and then ended up at that location. I further want to say if this location wants to portray itself as a market, then closing their doors at 11 p.m. would be reasonable for that community. I do applaud them for being a market for this area because I know this neighborhood does need a market, but I do not believe that the nuisance activity, it does outweigh the need for the market if it continues to operate in the way it does. In closing, I wasn't the investigating officer at this particular location, but based upon the size of this market, the issues, the crime stats, the testimony of the individuals associated with the surrounding businesses, and the fact that this location has 3 parking lots that are adjacent to it, I personally would have requested 2 security guards if I would have handled this case. So I think that this location is well deserving of one, and I think it would be a disservice to the community if you guys accepted the appeal of the applicant. That's all I have at this point.
Thank you, Officer. Dix, any questions for the officer?
I have a couple. The statement you made regarding a security guard there yesterday,
Yes, sir.
which was Monday,
That is correct, sir.
and what this condition talks about Thursday, Friday, Saturday, and Sunday, was that security guard for the taco place or was security guard for this liquor
That is security strictly for the taco place, not for the liquor store. Strictly. Now, what he advised me is that he has seen security there on various basis for the liquor store, and he actually feels safer that there's 2 rather than 1 security. But they're not there all hours of operation, and the security guard said that to me, that the taco location has security all the time.
24 hours a day?
Well, all the time that their business is open.
When they're open, and
Yes.
according to the document received from the appellant, the request, they have security guard Thursday, Friday, Saturday, and Sunday, and that's all they have, security guard. Have you ever noticed security guard there during any of the other hours?
When I am there on the off hours, I have not witnessed any security guard. Now, the security for the King Taco did mention that he thought that those were the correct hours for the security guard, but he says a lot of times it is hit and miss. Sometimes they're there, sometimes they're not. That is the testimony of what he had said to me.
But he's not employed from the taco
He
place?
is not, he is employed by the taco. He is not employed, I have not made contact with any security guard of the property at Wally's Liquor.
Very good, thank you.
Yes.
And
Yes, sir.
the other question I have.
Yes, sir.
It says also in their letter, the appellant, Newton Officer Carrillo, they mentioned him. Did you discuss this matter with him?
I did not discuss it. I discussed it basically with the city attorney, the zoning administrator, and vice officers from Newton, and briefly with the senior lead officer that's handling Officer Carrillo's area. He is off IOD at this point.
Okay, is he the senior lead, Carrillo?
Officer Carrillo is the senior lead for this particular area.
Okay,
Yes,
because
sir.
they do refer to him
I'm sorry?
Therefore, they do, the appellant does refer to that officer in their document, and it
Yes.
states, you can contact Newton Police Station, Officer Carrillo is on regular patrol, and help us and guide when we needed him. So I don't know what that relationship is, if he been called there or any other situation.
Yeah, I'm not sure, sir. He's been off IOD since I've been apprised of this case, so.
Okay, how long has that been approximately?
I've been handling the case for about 6 months, roughly, but I hadn't made contact with him. I've just been strictly dealing with the Newton Vice Area Office at this point.
Okay, but he is the SLO for that area?
That is correct, sir.
Okay, good, thank you.
Thank you.
Councilor Reeser? Okay. Thank you, sir, for your hard work and your presence here, and we'll let you go.
Thank you, sir.
Thank you very much. Now we'd like to ask the appellants if they'd like to come on up. I see two on the record. I believe it's Parvinder Singh. I apologize if I mispronounced your name. And Ravinder Singh, if you'd like to come on up and give us your case while you're appealing the conditions that have been set forth. Please give us your name and address.
My name is Parvinder Singh. Me and my brother, we are the owner of the Wallis Liquor. I understand there may be, this liquor store is there from last 40 years. There may be a problem in the past, but we bought this liquor store in March 2008. After that, we are trying to clean everything possible we can. You can patrol any time of the day, any time of the night. There is no people hang around of the store. We have a security guard because business is down like 30-40%. We have a security guard for 4 days, Thursday, Friday, Saturday and Sunday. And before we have a security guard 7 days, but business is down, it was hard to pay him even. It's hard to pay our employee salary even. And now in these days, you can talk to lot of people come from the neighbor, and I have too many picture from the store and the neighbor. Now everything is very clean and neat.
Can you see the
And people are not urinating or sitting outside of the store.
Can you forward your pictures and your letters to the clerk, please?
And also Officer Carrillo, he is a regular on patrol and over there. You can talk to him. He's always every day on the patrol. He don't see any problem. And you can talk to the community too.
Okay. Okay, thank you. Any questions for the gentleman? Some of the pictures you want to take.
I have a few questions
Yes, sir.
regarding your letter,
Yes, sir.
and you state in your letter that there's heavy competition in that area. Are there other liquor stores in that area?
Yes, sir.
And that's where the competition's coming from?
Yes, sir.
And that most of our sales generate from 10 p.m. to 2 p.m. Weekdays.
On weekends.
Well, you've got weekday and on Friday and Saturday from 10 p.m. to 2 p.m.
Yes,
Are
sir.
you talking about 2 a.m.?
Yes, sir. Only on Friday and Saturday we close 2 a.m. And weekdays we close 12 o'clock at night.
So you're saying the majority of your sales are generated from 10 at night till midnight?
Yes, sir.
Okay, so what is the problem if you open at 7 instead of 6?
6
Condition
o'clock.
is to open at 7 a.m. and not 6 a.m. If you're generating business at 10 p.m. and midnight and 10 p.m. and 2 a.m. in the morning, what's the problem with opening at 7 instead of 6?
6 o'clock because the store is over there 30-40 years. People come from the check cashing, Western Union for the coffee and bread because there is a bus stand outside and a lot of labor go to work.
Well, your letter says you're generating sales at other hours than what you're contesting. Your own letter says you're generating activity at a later time, not at 6 or 7 a.m. The other question I have for you regarding refused service to panhandlers and drunk people.
Yes, we are not allowing them since from last year. We are not allowing nobody standing outside of the store.
Well, you shouldn't have any drunk people at the store anyway.
I mean, it's a liquor store.
If you serve a drunk, if you sell alcohol to a drunk, that's another ABC violation.
No, we're not serving to the drunk. If we see people are drunk, we refuse them.
Where are they coming from?
There are 3 other liquor stores over the surrounding area, sir.
And this Officer Carrillo's been off injured on duty for 6 months. How are you communicating with that officer who's not even at work?
Which officer, sir?
Officer Carrillo.
Yeah, we keep calling him, he keeps searching the area, he's patrolling the area all the time.
He hasn't been there for 6 months, according to the other officer. He's been off injured for 6 months.
I have no notice or no letter, but he patrolled regularly to that area. And this new officer, I don't know him, he never approaches, I don't know what is his name even.
He works undercover, that's why you don't know who he is.
I
He's
see.
undercover officer. That's why. Thank you.
You're welcome.
That's all I have.
Okay. We start, Ravinderjit Singh. Okay, then we have Ravinder Singh. Would like to speak?
Yeah, my name is Ravinderjit Singh, and 12228 Granada Hills. Sir, this store is from last 40 years, and my brother mentioned. We got the store last year, and since then I agree with you that there was too much problems in that area. Since we are there, we are trying our best with the help of police to clean that area, and to be very honest with you, right now we have achieved almost more than 90%. We don't sell those people, and there are only 8 to 10 people. They were making problems, they were just hanging around in that area. And we know those people and we don't sell them, that's why they're alcoholic. They will go where they will get the alcohol. We don't sell them alcohol and we don't see them anymore. Once in a while if somebody come, we completely refuse them. That's why, you can check with our community. And we have all the cameras outside, inside, and the place is, honestly, it's not like I'm saying it's my store, but to be very honest with you, place is very clean. We don't have any problem right now. And as regard the morning is concerned, there are a lot of servings in the morning. People, it's a clean and people go to work, they buy coffee, they buy their regular use, they cash their checks, That's why they're used to, because these are the services this liquor store is providing from last 40 years. So that's the request if we want to keep the continue what they were doing,
Okay.
Yeah. Thank you, sir.
Thank you, sir. Is anyone else with your group that are part of the appellants? On record, no, not the community groups yet. I'm just talking about the applicant. Okay. All right, thank you. Now, I did get a request from the clerk that police officers wanted to set the record straight based on their observations. And can you give us your name and your background and how long you've been familiar
My
with
name
this
is Dan
case?
Reedy, R-E-E-D-Y. I work Newton Division, 3400 South Central Avenue.
Good afternoon, sir.
The question I just want to clear up is that Officer Carrillo's last day was on Thursday. Today he had surgery, so Carrillo has been working on this up until last Thursday. So starting today, the 17th, Carrillo was IOD. That was the point I just wanted to make.
Okay. There's a card from another officer. Do you have it? I'm just a little confused. There's a from the Antonio Melendez, a card that speaks to the petition for surrounding neighborhoods for help and dispute. I, Officer Melendez, have not received other dispute calls, and it's dated October 28th. And so I'm trying to get some consistency here. We have this card from Officer Melendez, yet we have the comment and observations from Officer Dix. And is there any way you can respond to this card?
I have no idea about that card.
Show the card.
If I may look at it.
It's a business card and has information on the back, a 620 business dispute.
So I just want to make sure that we're all on the same page. If there was an observation from the police department, obviously Officer Dix has made, for the record, his statement. You're making your statement. If there's a card here from an Officer Melendez, do you have an Officer Melendez in your unit or in your area?
No, sir. Officer Carrillo is a senior lead officer, just like I am. He works out of our office at
Okay.
Newton Division. This officer looked like he is a patrol officer. He worked 13893 on that date, and I don't have no idea what occurred on October 28th at, was it 10 10:25 PM. I
So it's
believe.
one incident that's responding to.
That's correct.
What's a 620,
Business dispute, sir.
not a 415?
No, sir. 620B would be like a business dispute.
Okay, again, just to clarify, because he did submit it as evidence of, I guess, support that he's received. And again, I just want to get some clarity.
I got a point of clarification. This business is at 1955 South San Pedro, which is at 19th and San Pedro?
Yes, it's just north of 20th Street in
Because
San Pedro.
There's petition signed here from folks on 35th Street and other locations that aren't East 4th Street, 47th Street. I find it interesting that people would go that far to a local liquor store from 47th Street to 19th and San Pedro. So while this petition lists the establishment there for the last 30 years, a number of, I guess, customers have signed it, but I don't see them as customers that live immediately adjacent to that liquor store. West 81st Street, there's a number of locations here that are a far cry from 19th and San Pedro. Just want to note that for the record also.
And also for the record, I just know that the area's been a problematic location for Officer Carrillo for many years. I don't know the relationship the last 6 months, but I know Officer Carrillo's been working on that location very diligently.
Okay. Thank you, officer. Thank you for that clarity. That being said, we'll go through the speaker cards, and
Did you see this, Jose? Did you see this?
so we'll start with Victor. I believe it's Ichalai and 705 East 21st Street, with un grupo de gente de la comunidad, Rafael Pérez and William Neves.
Víctor Echeagaray.
Ichalai. Afternoon.
Yo soy testigo de ese negocio por 42 años y la comunidad, todo alrededor.
Dame un minuto para ver si Roberto puede interpretar por nosotros.
I have witnessed that business for the past 42 years.
Y estamos acostumbrados, mi familia, la familia de mi esposa, todo a las horas que funcionaba la licor por tantos años. Y parece ser que van a recortar horas a la licor y la necesitamos mucho, que se acaba la leche del niño y cruzan la calle a la 1 de la mañana. Y ahí
He says his family frequents the business and they rely on the business to buy milk.
Okay.
y la licor hoy en día ha ido mejorando en todos sus aspectos, tanto interiormente como en el exterior. Hay limpieza.
That they have made changes to the business, the inside and the outside, and a lot of improvements.
Todo esto se ha hecho con la finalidad de darle un buen servicio a la comunidad.
That all of this has been done to give the community good services.
Y ruego a estas distinguidas personas que representan el gobierno de Los Ángeles que atiendan lo que pide la comunidad.
And I ask this distinguished committee to listen to the community's needs.
Y esperamos que consideren ustedes que la comunidad tiene necesidad de ese negocio porque tiene medicina, tiene leche, si ocupan a la 1 o 2 de la mañana leche, cruzan la calle y la compran, y alrededor hay tantos negocios cerrados.
And I would like to tell the committee to please consider that this business provides services to the community, milk and medicine.
Así es que ruego en nombre de la comunidad que nos den el servicio que ha venido dándose por 42 años.
And please consider that this business has provided services for 42 years.
Gracias, señor, por la participación. Agradezco mucho.
Okay, gracias.
Okay, Rafael Pérez.
buenas tardes. Me llamo Rafael Pérez. Yo he trabajado en Wallace desde 1987.
Hi, my name is Rafael Perez. I have worked at Wally's, ¿cuántos años?
Desde 1987.
Since 1987.
Sí. Conozco también todo el vecindario, conozco toda la comunidad.
I know the neighborhood and the community.
Y pues ahora en esta ocasión siento mucha pena que esté sucediendo esto con este negocio, porque siempre se le ha brindado a la comunidad el mejor servicio y se le ha ayudado en todo lo posible pues para salir adelante y sobre todo para las necesidades que tienen las familias, sobre todo.
I'm sorry that this is going on. This business has provided services for 42 years to the community and to the families.
Yo puedo ser testigo de la diferencia que hay ahora a lo que había anteriormente. Trabajé con el primer dueño, con el segundo y ahora con los señores nuevos propietarios, y ellos han trabajado muy duro para poder tener limpio, para poder tener tranquilo y para poder ayudar a todo el mundo.
I have been a witness since I have worked for the first, the second, and now the third business owner, and I can attest to the fact that they have cleaned and have made improvements to the business.
Y les pediría por favor que continuemos con los mismos horarios abiertos, que no nos cambien el horario, ya que también como trabajadores necesitamos la ayuda de todos ustedes, porque de ahí pues sacamos nuestros salarios para mantener a nuestra familia.
I ask you not to change the hours of operations because they help workers like myself and we need the wages.
Muchísimas gracias a todos.
Thank you very much to all of you.
Gracias, señor, por tener el tiempo. Rudy Nieves, and then we have Brandy Chappelle. I'm sorry, Brandy, if we can have you last. After Brandy Nieves, we have Hugo Zapeta.
Good afternoon. My name is Rudy Nieves, and I've been working at All People's Christian Center for the past 15 years. Just recently, we've been having an increase of homeless people that have been coming over from Mission, San Pedro and 7th, over that area, over towards our area where we're at now. We've experienced in the past few months one homeless person who actually walked over towards our facility and died in front of our center. This happened around 3 o'clock in the afternoon, and we had approximately 50 to 70 kids outside. He just passed out, wasn't able to wake up again. We had to call the paramedics. This happened during the summer of this year. Not too long ago, we had our vans broken into and the battery was stolen. And not too long ago, about a month ago, we had some of our students who are middle school age, 2 young girls, report to us that some gentlemen who are homeless that were drinking tried to grab their hand. So it's an issue that continues to exist. They might not see it, but we are there. We're there. Our operating hours are from 6 to 9. We open Monday through Sunday. We do have approximately 300 to 400 families, children, and individuals that come visit our center for services. It's a shame that our children have to walk from San Pedro over to our center, which is only 3 blocks away, and in order for them to get there, they have to cross through Washington and San Pedro, which is a huge intersection, and on top of that, they have to walk around, sometimes going onto the street, because they cannot walk through the sidewalk because they're laying down, passed out. Unfortunately, they wake up at night because after their hangover, they wake up and they continue to drink throughout the night. And once again, we show up to work, and lo and behold, they're laying out,
Mr.
passed
Nieves,
out.
just for the record, you indicated incidents of this person dying and
Yes,
cars broken into. Are you saying
our
that
vehicle broken into, our center van.
your center? So what you're saying is that those crimes emanated from this address?
Well, we cannot prove that, but we noticed that there's been an increase of trash broken into our vans, and our children are reporting to us what's going on when they walk to our center from school. We have to take into consideration everything that we are witnessing and experience, and we have to take a stand to correct these issues.
You're saying that there are people lying on the sidewalk.
Yes, there
and
is.
everything
There's
else
people lying
in
on
front of the store?
On 20th and San Pedro, which would be a corner of 20th and San Pedro, there's a parking lot, which is a auto parts store. They sit there and lean against the iron fence and drink. There's a house between that parking lot, which has a gap about maybe this big, maybe smaller. They urinate there on the side while people are passing. There's an alley also on 20th, not our alley on 20th, but on the other side of the street on 20th, there's an alley that's open, and there's businesses there. But unfortunately, that's where they like to hang out, and it's only around the corner from where we're at.
Thank you, sir.
Another thing, too, we've have a food program on Fridays, and we've noticed that they come and for services, and so we know that it's a high volume of them that show up on certain days, too, to our center.
Thank you very much.
Okay.
Thank you, sir. Hiro Zapata and Diana Zapata. Have to come on up. And that'll close public comment for this item. Please.
Hello,
Hi, good afternoon. Please give us your name and address.
I'm Diana Zapata, and we're concerned with the address at 2014 South San Pedro Street.
Speak to the mic, I can't hear you.
Can you speak right into the microphone? We'll hear you a lot better.
We're concerned with that. Our business is at 2014 South San Pedro Street. We own the building, and we have tenants, which is straight across from Wally's. And there are homeless laying around all the time. I go down to the business to check on it every so often, and I'll see guys laying on the sidewalk, and one guy even told me, "This is my space, you can't touch me." And I've seen people at Wally's standing outside drinking, a security guard standing way over on the other side. And we've had the building for about 30 years now, and it's been a continual problem.
Okay.
So he can tell more because he spent more time down there.
Thank you.
Tremendous nuisance also for our tenants. And the previous fellow that just came to the mic, we have been experimenting all the problems that he's having, exactly. People urinating, trash all over. These guys are urinating in front of kids coming from the school around the street at all times of the day. We have to call the police to have them removed. We're sick and tired of our tenant complaining to us constantly, they're telling to move. And graffiti, and it's just a total nuisance for us. I've been in that building for over 30 years.
Okay.
And it's not just with them, it was also with the previous owner. It's always been a nuisance and a problem.
So you're the property owner,
Yes.
and they are a tenant in your building?
I right now have yes, it's for lease,
I see.
They're
Okay.
having a tremendous problems too. I did because I did run a business there for about 30 years, 29 years to be exact.
I see.
I stopped having the business in 2003. Ever since then, I haven't a tenant in there. But it's a tremendous nuisance for us.
So you agree with the conditions that are being suggested by the planning department?
Yeah, I
Okay.
just want it to be corrected. It's
Okay.
unbearable.
Okay. Thank you very much.
You know,
Our last speaker is Benny Chappelle, a council member of Jan Perry's office.
Good afternoon.
Good afternoon.
For the record, I'm Brandy Chappelle, Planning Deputy for the Office of Councilmember Jan Perry, and I'll be very succinct. The council member is very clear in her position. She supports the discretion of Zoning Administrator Sue Chang in establishing corrective conditions for this venue, and she fully supports Newton Police Division and Detective Support and Vice Division. Steve Carrillo, Dan Reedy, and Officer Dickus have had long-standing relationships with our office. She defers to their discretion, and she asks that you deny the appeal. Thank you.
Okay, thank you very much. That being said, callers, that concludes public hearing. I'd like to know that I deny the appeal filed by Corona Corporation. Governor Judge Singh absolved and will be sustained The decision is any administrator in finding that the operation of the business known as Wally's Liquor located at 1955 South San Pedro Street is a public nuisance and requires a modification of its operation to mitigate adverse impacts. That is second, that be action of this committee. Thank you very much. Our next item that involves the police department, I think, is item 12. No? Well, okay, the police is not here on item 12, so we'll start with, we'll go back, Roberto, with the chronology of items. So that takes us back to
Item 1.
Okay, item 1's been continued for 2 weeks. No, that's it. So item's been continued for 2 weeks.
Right, but I believe you had...
And we can have some cards, that's right. Now, there's folks that submitted cards, and again, out of respect to your presence here, we're going to have this hearing in 2 weeks. Do you feel compelled to speak? If you do, come on up to the microphone and give us your name and address and your statement. Anybody like to speak? If not, on item 1, okay, then we will continue item 1 for 2 weeks. That being the case, we go to item number 2, Roberto?
Yes, Councilman. Item 2 is a motion of Garcetti, Han for yourself, and it's instructing building and safety to initiate various policy directives as relates to billboards.
Okay. The department report on this?
I believe staff is present, but since it's I believe it's a referral to staff, Councilman.
Okay, there's no report on this. So we go into public comment?
Yeah.
And we will start, because of the volume of cards on this item, we will give everyone 1 minute. So Patrice, if you don't mind. And we'll go through the list. This will force everybody to be as succinct as possible in their statement. Our first speakers will be Ken Person. Next speaker will be Mort Allen. Then we'll have Richard Spicer, I believe. And then Laura Brew. I'd like to come on up so we can move this item. Come on up, sir. Give us your name and address. You got 1 minute.
Thank you. My name's Ken Person. I work for YESCO, and I'm here to discuss the motion to make a decision about what to do with the decision handed down from the summit agreement and what the committee will do from here. I would urge the committee to consider all issues, of course, and definitely urge the committee to consider going back and thinking about sensible legislation that gives us an opportunity to regulate with time, place, and manner restrictions this great new emerging technology of digital outdoor. Digital outdoor advertising displays provide a highly effective method of communication, offering significant public benefit. To name a few, all digital billboards in California are wired to the National Amber Alert system to quickly identify and find missing or exploited children. The billboard industry donates $400 million in public service advertising each year.
Thank you, sir. That's that 1 minute. Thank you very much. Mort Allen, just like keep an eye on the clock. And it's right to your right, so.
Hi, Mort Allen, Studio City. I just want to say I was on the original City Council Billboard Ad Hoc Committee 10 years ago when we started on all this. I think it's gone a long ways. I just want you all to remember that LA was founded with palm trees, movie studios, and billboards. Billboards are what sold the tracks, all the stuff. We need them. It's gotten out of hand. I think you have one of the smartest lawyers there is as your city attorney and the staff. I think that you got to just really sift through this all, and we need billboards. I know that the public, from what I know, people do not mind billboards. They mind them in residential areas, and they do not like the wall graphics. But I think that if you take the lead of the city attorney, we'll get this resolved. Thank you.
Thank you. Now, 1 minute. John Reichman, Richard Spicer, and then we'll have Laura Bill. Good afternoon, sir.
Yeah. My name is Richard Spicer. I'm here representing the Greater Griffith Park Neighborhood Council. We have been before you on billboards. I'll remind you what that was. We're against illegal billboards. We started with our own survey. We're happy to say that building and safety This was in 2007. They tell me the survey is done, and they will know which ones are illegal by January. We also are taking up the Hollywood Community Plan, opposed to illegal billboards. We have submitted to Planning Commission, to Plum, and to City Council a community impact statement in which we have a number of points on a good, sound ordinance. That should be enforceability, stand up to the courts. We have resubmitted those today in order to be on the record for this ordinance. We weren't able to be here in August when it was passed. Thank you very much for your work on this subject.
Thank you, sir. Jan Reichman, Laura Bill, come on up.
My name is Jan Reichman. I live at 1429 Comstock Avenue. I'm president of the Comstock Hills Homeowners Association, a neighborhood within the shadows of a huge digital billboard at 10333 Santa Monica Boulevard in Westwood. We strongly urge you to support converting digital billboards back to conventional. The court has ruled that the settlement allowing the digitals was unlawful. It's time to end the suffering from blinking lights flashing into our homes and backyards and the nonstop noise emanating from the huge cooling fans. Why was no notice given to residents when permits were being issued to the billboard companies? Surely the city knew of the impact to those citizens. It is clearly a CEQA issue, yet the city allowed a secret settlement with no public review. When a cell site is proposed, notices are given. If we need to sell our homes, this disclosure surely devalues our property. I guess my time is up. Do the right thing.
Thank you very much. Laura Bill, Richard Simon, and Barbara Boyd.
Chairman Reyes, I'm here for CBS and Clear Channel, and between myself and Clear Channel, we have 7 speakers here. I would like to ask that the 7 of us be consolidated so that I can split time between myself and Greg McGrath, the president of Clear Channel Outdoor.
Well,
the others would sit down and give up their time.
Well, why don't we just go with the order that we have, and 1 minute each. Go ahead.
Thank you. Chairman Reyes and members of the committee, I'm Laura Brill, outside counsel to Clear Channel Outdoor and CBS Outdoor. I'm here today to encourage you to either reject this motion or at a minimum not to move forward with any specific ordinance amendment until you have been fully briefed by DBS and the city attorney. The motion was submitted before Judge Green issued his final order in the Summit case and before CBS and Clear Channel appealed. The motion unfairly attacks Clear Channel and CBS's existing signs and would render meaningless their right to appeal. We believe Judge Green's decision contains many legal errors. These errors include an unduly narrow reading of the council's charter power to settle litigation. If not reversed, the decision will have a damaging effect on the city's ability to settle a wide range of lawsuits. In a previous federal case, the city vigorously opposed a narrow reading of its charter power, and it should do so again here. Consider an artist with an artist studio, and the area is zoned as residential. The city has to, the city has to be able to make a determination about whether that use is residential or not.
Thank you very much. Richard Simon, Barbara Boyd, and Baron Cohen.
Hi, good afternoon. Richard Simon, also of Kendall, Brill, and Klieger, speaking on behalf of Clear Channel Outdoor and CBS Outdoor. I'd like the committee briefly to consider where the Summit case stands. On November 5th, CBS and Clear Channel appealed to the Court of Appeal, and Superior Court Judge Green's decision is stayed pending that appeal. This motion is asking you to implement a decision while it is still under review. Moreover, there is nothing in Judge Green's decision that requires the council to take any action, and a rush to pass the motion now would be rash. Rash because the committee and council have not been briefed by DBS and the city attorney regarding the negative implications. Accordingly, I encourage you either to reject the motion or, at a minimum, not to move forward with any specific ordinance amendment until you have been fully briefed by DBS and the city attorney. Thank you.
Thank you.
Good afternoon. My name is Barbara Brady, representing Westwood South, the Santa Monica Boulevard Homeowners Association. We strongly support Garcetti's motion. The court has left it to the city to take action and implement the court decision. We have waited a long time for this decision. We were denied our fundamental rights to public process when signs were placed in complete violation of our community plans. I had a story that I was going to read you in some order, many chapters beginning last August when we filed our first appeal against a digital sign that appeared in violation of our neighborhood ordinance. We've been waiting since that time and going through the city's Byzantine process to get a decision. We had a hearing in June. We still don't have a decision on our appeal. We have 3 pending appeals. It is not reasonable to expect citizens to have to appeal signs individually. The city needs to create a process to do so, and it needs it now. And if for some reason these people are successful in delaying action and enforcing this to go back to the lawyers, then just shut the signs off meanwhile, so that we get some moment of relief and justice. Thank you.
Thank you very much.
Hello, my name is Marilyn Cohen, and I'm the Vice President of Westwood South of Santa Monica Homeowners. I'll just leap in the middle. We decided to challenge 3 digital billboards, which were approved counter to clearly defined specific prohibitions. Sounds simple? There was no appeal form. We had to create one. There was no agency which would accept the appeals. Days of attempting to file the appeal were unsuccessful. We had to hire an attorney to guide us through the process. Finally, Building and Safety was ordered to accept the appeals. Months later, they told us they had to be filed with planning. We had to begin the process once again. It took 1 year for them to schedule the hearings. Today, 5 months after the hearings, we still have not received the results. We urge you not to put us through this ineffective process, 1 pixel at a time, relying upon administrative remedies to resolve problems which should never have been created in the first place. We must find a way to undo the damage created in our communities without putting us through this tortured and fruitless process. The illegally converted digital billboards must not be permitted to remain. Thank you.
Thank you very much. Our next set of speakers, Tim Fox, Anthony Alden, Mark Gatto, and Dennis Hathaway. Please come on up. That was Tim Fox, Anthony, I believe it's Alden or Aldu, I can't tell, Mark Gatto, and Dennis Hathaway. Come on up. Tim Fox.
Tim Fox has left the building and wants.
Sorry?
Tim Fox has left the building and wants to defer his time if possible.
No, but thank you. Anthony Alden.
Good afternoon, Anthony Alden from Quinn Emanuel, representing Summit Media. I just want to make 2 very brief points. One is that Summit Media has spent a lot of money and a lot of time in getting rid of this settlement agreement and giving the city an opportunity now to do this right. And the city, I urge the city to take that opportunity and to make the billboards go back to conventional, and then if CBS and Clear Channel want to apply for permits, they can do so. There's nothing wrong with Judge Green's opinion. It's perfectly legal. In fact, you've previously been told that the decision of Judge Green has been stayed. That's not the case because, in fact, the notices of appeal are premature, and today Summit has in fact filed a motion to dismiss the notices of appeal. There is no barrier, no legal barrier, to the city taking action now, and that's what the people want. The city can express the people's will and can establish a proper and fair regime that starts from scratch.
Thank you very much. And this closes public hearing. There will be no more cards accepted. If you do submit your cards, we'll add your cards for the record, but we will no longer be hearing any more cards. So Mike Gatto, Dennis Hathaway, and David S. Ewing.
Mike Gatto, 2611 Armstrong Avenue. In the recent litigation, other members of my law firm helped represent Summit, the little plaintiff that could, who successfully challenged the illegal digital billboard agreements. But today I come to you simply as a resident of Silver Lake, where one of the most intrusive digital billboards has disrupted a community. While I come to you before you as a citizen, I will also try to dispel certain legal misconceptions that are floating around about this matter. There are many. I'll cover just 2. First, there is this notion that revoking the permits for the digitals will somehow make city contracts unstable, or that business owners will not be able to rely on contracts with the city. This is nonsense. If I sue the city because, say, a garbage truck hits my car, and the city settles my lawsuit by allowing me to exceed the speed limit for the rest of my life, that's an illegal contract. It's illegal from the get-go, and no one can or should rely on it. We have the same situation here. The second misconception is that you have to wait until the appeals process exhausts itself. This is another myth. You have a judgment from a competent court that says the settlement agreements are illegal and always were. If you act now, your decision can take effect the minute the appeals are resolved.
Thank you very much. Dennis Hathaway, David S. Ewing, then Barbara Monahan-Burke.
Thank you. Good afternoon. My name is Dennis Hathaway. I'm president of the Coalition to Ban Billboard Blight. We urge support of the Councilman Garcetti's motion. The companies are arguing that to void the permits for these digital billboards would be unfair and an act of bad faith on the city's part, even though the judges voided the lawsuit settlement. I would argue that the city's action in approving this lawsuit settlement in the first place, behind closed doors without a single moment of public debate, was a huge act of bad faith towards its own citizenry. Sorry.
We understand.
Its own citizens. Couldn't wrap my tongue around that one.
Thanks.
And the only way to make amends and act now in good faith is to tell those companies that the billboards have to be restored to their original state. Thank you.
Thank you very much. David Ewing, Barbara Berg, and then Ingrid Miller. Good afternoon, sir.
Good afternoon, Councilman Reyes and committee. The judge's ruling in the Summit case voided the lawsuit and said that we as citizens were denied our rights under law to have a voice in the decisions that significantly affect our communities. The judge called the entire settlement poison. I call it poison slime. These digital billboards should never have gone up without notice to surrounding property owners and residents, and public hearings that would have allowed citizens to comment on such issues as light pollution, energy usage, and traffic safety. And then the City Council adopted the lawsuit settlement after a closed session without a single moment of public debate. The only right thing to do is to declare the permits issued thus far to be void and require the companies to return the billboards. May I proceed just
Please finish that last statement.
I urge the committee to pass Councilman Garcetti's motion. The city needs to move ahead in coordination with the city attorney's office.
Thank you.
This is a minefield. You guys have stepped on mine. Please don't do it again.
See what happens? Barbara Manahan-Berg? Barbara Manahan-Berg, are you here? Okay, Ingrid Miller, Laura Salaji, and Greg McGrath. Good afternoon.
Good afternoon. How are you? I'm Ingrid Muller, 21 resident in a historical building in Venice. So you can imagine my surprise after about 20 years of activism in that fabulous community when one week all of a sudden on Lincoln Boulevard this billboard jungle appeared without any public input at all. And not only that, then the Los Angelinos all over the city were forced to find their way into all kind of administrative other jungles to oppose these ugly things that took away my blue sky, as I call it. So I really am happy about Judge Green's decision, and I certainly support with thousands of Los Angelinos, Council President Garcetti and Council Member Hans.
Thank you, ma'am.
Thank you.
Please.
I'm Laura Salaji, 1072 Palms Boulevard, Venice. I represent the Venice Community Coalition, and I support the Garcetti motion. My neighbors Mindy and Jack Ross live a block from a digital billboard on Lincoln Boulevard in Venice, and they have complained that they are disturbed every night by changing light that pulsates through their bedroom windows, and others have the same experience. They were unable to come here today because they are working. However, the billboard industry lobbyists and lawyers are paid to come to these meetings. Citizens have been denied their right to public process regarding something that significantly affects their quality of life. The judge's ruling basically said that they and other citizens have been illegally denied this right to public process. Therefore, it seems only right and logical that all these digital billboards should be converted back to standard billboards.
Thank you. We have Greg McGrath, Anthony Roman, John DeLong, and William Lawson. Good afternoon, sir.
Thank you. Chairman Reyes, members of the committee, my name is Greg McGrath. I am president of Clear Channel Southern California, Los Angeles Division. Clear Channel has operated in this great city for almost 100 years. Just 5 years ago, we renewed our commitment to the city when the LA Unified School District requested to use our property, our former location, to build a new high school. Clear Channel worked with the city and Genesis LA to find a new home, and we relocated our office and our 135 employees to stay within the city of LA. The motion before you today gives us grave concerns. We are concerned that the city is considering taking unfair advantage of a business that has been in good standing in this community for almost a century. We are concerned the city is looking to extract all the benefits of the settlement agreement for itself while simultaneously walking away from its own commitments, including the unanimous approval of the existing digital signs. In 2006, our company began looking into the digital technology as a new way for changing our messages. Given that it was a new technology, the resources and cost to convert the digital was immense.
Thank you, sir.
Thank you.
Next speaker.
Good afternoon, Chair and Committee. Anthony Roman, Clear Channel Outdoor Public Affairs Representative.
This is a continuation?
Yes.
All right.
We sought reassurance from the City Council that we were moving forward in compliance with the law. The City Council exercised its right reasonably, interpret its code, and represented to us that such signs were lawful under the law existing at the time. To consider reneging on this deal is fundamentally unfair and just can't be the policy of this city. It sends a terrible message to the businesses. The business community and the city has no regard for its contractual commitments, and that businesses will be punished for working with the city to settle disputes. If the city did require the digital to be removed, the message we receive and the entire business community receives is that cooperation will leave you worse off than if you disregard city regulations as many other sign companies do. The agreement with the sign companies was...
Thank you, sir. John Duong, Lynn Lawson, and Laura Township.
Good afternoon, Mr. Chairman and members of the committee. My name is John Duong, Vice President of Clear Channel Los Angeles. To continue the previous speaker's thoughts, the agreement with the sign companies was negotiated by the city attorney and approved by a unanimous city council by the mayor and the judge of the Superior Court. The major terms of the agreement, including the planned digital conversions, were all voted on and approved by this city council in open session. Obviously, the city thought it was a reasonable agreement at the time, or it wouldn't have gain all these approvals. We understand there are competing interests before you today. However, the most significant priority should be to honor your words. It is one thing to pass an ordinance prohibiting further digital conversions. We support the city's police power to do that, and have always agreed with the city had the power to change its laws. But it is quite another thing to agree with the project can move forward as lawfully issued 101 permits to complete the project. Watch while your good corporate citizens spends millions on the project and then entertain an ordinance that would take away the citizens' property after it's cooperated with the city.
Lynn Lawson.
Next line.
Then Laura Township. Good afternoon, sir.
Lane Lawson, Director of Public Affairs, Clear Channel, Los Angeles. What reputable company will ever enter into an agreement with the city or settle litigation if the city takes this kind of approach? It identifies Los Angeles as a difficult and unpredictable place to do business. Those who criticize the settlement agreement overlook the benefits to the city. Together, Clear Channel and CBS paid approximately $1 million in fees to the city and agreed to an unprecedented degree of disclosure of business information. It was because of the agreement that the city was able to launch its off-site inspection program, which is the key to the city's long-term enforcement efforts and to any possibility that the city will be able to eliminate the unpermitted super graphics that have gone up throughout the city without any regulatory oversight. Our digital signs stand on a totally different footing than the super graphics. We applied for permits for every single sign that we put up. We were subject to rigorous review and inspection by DBS and the planning department for our digital signs.
Thank you very much. Laura Township.
Laura Township with Clear Channel. We also committed to taking down 100 sign structures, no question asked, and these structures have come down. Judge Green made a very important finding in his decision on November 4th. He said that we reasonably relied on the settlement agreement. We expended considerable resources obtaining approvals and installing displays throughout the entire process. No one at the city ever said that digital conversions were unlawful or would have been forbidden in the absence of a settlement agreement. In December 2008, this city banned digital signs for the first time, and we have not applied for a single digital permit since then. I want to mention that while some folks here today have spoken out against digital signs, this hostility is a minority view. The independent media research firm Arbitron conducted a survey and concluded that the majority of Los Angeles County believes they are attractive and provide an important community service. Thank you for your time.
Thank you very much. Maya Zedler, John A. Wellborn, Jean Barrett, and Ray Baker. Good afternoon, ma'am.
Good afternoon. Thank you. Maya Zettler here from VICA, Valley Industry Commerce Association. VICA is here today to express our strong concern for this motion. Companies acted in good faith and complied with the settlement agreement at a great cost to them. Allowing the court to revoke permits for construction work that has already been completed is a huge cause for alarm. Businesses in our city need to know that the financial investments that they make are going to be protected by contracts that they hold with the city. This is not the first time that we have been here. By responding to this ruling, the city is setting a dangerous precedent. Aside from the many risks and challenges that business have to go through in these tumultuous times, when it comes to operating here in the city of Los Angeles, they now have a reasonable fear that a valid contract with the city provides no protection for their investment. It is unreasonable to ask that these outdoor advertising companies remove their signage that were built with legally obtained permits. This could potentially cost the city up to hundreds of millions in liability. We are asking that a clear message be sent. We must protect businesses from this kind of risk.
Thank you very much.
Thank you.
John H. Wellborn, Jean Barrett, and then Ray Baker.
I'm John Wellborn, the president of Scenic California, and that's my capacity here today, and I am representing Scenic California, which is the affiliate of Scenic America. I would like to say Dennis Hathaway talked about a mistake made by the council. I look at it as a mistake made by a city attorney who isn't here anymore. It's not your guys' fault. My main reason and purpose for being here today is to urge you and your colleagues to make good jobs. I'd like you to take this opportunity through the Garcetti motion to set forward something that will provide jobs for skilled workers, well paid, taking down the digital billboards. And those digital billboards can then be sent to cities, counties, and states that would like them. The beneficiaries are the workers, the populace around the billboards, and the billboard companies still have their signs that they modernize that they can have back as regular ones. Thank you very much.
Thank you, sir. Jean Barrett, Ray Baker, and then Ryan Brooks.
Yes, my name is Jean Barrett. I'm a 21-year resident of the Hollywood Hills, and I'm on the board of directors of the Hollywood Knolls Community Club, and we have another one of our board members here as well, Sandy Gitmed. I would like to speak out against digital billboards. They're distracting to drivers, and they ruin the visual landscape. Beautiful and iconic views in Los Angeles are now obscured by the blinding light and flashing graphics of these eyesores. Attractive residential neighborhoods around the city have been invaded by Las Vegas Strip-style flashing billboards. And now a judge has ruled that the city had no right to make that ridiculous backroom deal with the billboard companies that allowed the first digital billboards to go up. That means that the billboard companies had no right to convert those digital signs. So the answer should be clear. All those digital billboards must be converted back to conventional signs, so long as those original signs were legally permitted. Thank you.
Thank you, ma'am. Ray Baker, Ryan Brooks, and Gregory Wright.
Good afternoon. Ray
Yes,
Baker,
sir.
Lamar Advertising. I'm the Vice President and General Manager for the Los Angeles office. First of all, thank you for taking the time today. Secondly, we've been dealing with this issue now for 18 months or more here in the city. There's been many, many hours of hearings as well as time spent. It is my position that now is as good a time as any for the Plum Committee as well as the Council to take on the issue of providing the city with good, solid time, place, and manner zoning, and coming back and revisiting the motions that were set in place just a few short months ago, and to take the time to address those issues and create a good ordinance for the city and avoid any future litigation or potential liabilities that the city's already created for itself. Thank you. Have a good day.
Thank you, sir. Our next speaker. Good Good afternoon, sir.
Councilmember Ryan Brooks, CBS Outdoor. It's ironic that CBS stands up here right now, and we heard the Summit lawyers, the well-paid lawyers here, talking about how great they are. The little company that could is what they said. Let me tell you what that little company could do. They could take down their illegal super graphics in the city. They could turn over their inventory to the city. That's what they could do. Councilmember, we've been here. We entered the settlement agreement in 2006. We did it with good faith. We made a deal. CBS turned over our inventory. We paid $500,000 to the city so they could have a strong inspection fee program. We took down 3% of our legally permitted signs in this city. We shook our hands and we looked you in the eye. We said, here's our deal. We felt at the time that we did it within the right time with permits. Council members, this is about integrity. This is all this is. We sat down, we made a deal. We provided you with our permits. We gave you $500,000. We took down legally permitted signs in the city, and integrity is all we have left right now. So hopefully you'll maintain that integrity and keep our deal. Thank you very much.
Thank you, sir. Gregory Wright, Beverly, I believe it's Kenworth, Noah Weiss, and Andrea Weltman. Good afternoon, sir.
Hello. Can you hear me?
Just bring the microphone down a little bit. There you go. There you go.
Thank you. I am Gregory Wright, testifying as a citizen of Los Angeles and a resident of the Los Angeles environment who is sick of living in the sea of ugliness that is this city. Adding injury to the insult of the visual blight from both digital and conventional billboards is the fact that nearly half of the electricity in this city comes from burning coal. There is no way this city can continue to allow tens of thousands of digital and conventional billboards, even blank ones, when there's nothing on them, to burn for hours on end, night after night, in a time of carbon loading of the atmosphere and out-of-control climate change. Both digital and conventional signs need to be eliminated, I believe, and that can start with their de-illumination. And then Los Angeles can announce this good act at next month's Copenhagen Climate Conference.
Thank you, sir.
Thank you.
Okay. Beverly Kenworth, Noel Weiss, Andrea Waldman, and Michael, I believe it's Hugh.
Good afternoon. Beverly Kenworthy with the LA Area Chamber of Commerce.
There's a familiar face.
Is that better? Yes, it is. How are you? The LA Area Chamber members are concerned by the city's decision not to defend the agreements that they have made with the billboard companies. We feel that it's a bad precedent, sends a chilling message to the business community, and possibly risking costly additional lawsuits. On a side note, I'd also like to mention and remind the committee that of the distinction between the on-site and the off-site issues. We are hearing numerous complaints from the business community that their on-site sign permits are not being issued and that they're being delayed and they're getting caught up in the off-site issue. They are separate issues, and we need to have that message trickle down to building and safety and to the counters so that these businesses can get their signs up and running so they can attract business to Los Angeles. Thank you.
Thank you. Noel Weiss, Andrew Whitman, Michael McHugh, and then Dan Silva.
Council members, I don't understand how the city, how anybody could reasonably rely on the city's entering into an agreement to give away its police powers over the ability of the city to basically protect its citizens. And yet, this is basically, I think, an issue that is going to have to be hopefully done in open session and not in closed session. And my point is, whatever is done, that the debate not be in closed session like before, but be in open session, and that essentially, as you reconcile these conflicting economic and political interests, that we do so with some overriding values, namely basically the ability to deliver to the citizens the services that the council has to do. And in the end, if you end up having to pay, then you'll end up having to pay. But at least that will be part of the debate, and so that the net result will be hopefully something that is reflective of some finality and some fairness across the board. Thank you.
Thank you.
Good afternoon. My name is Andrea Weltman. I'm a longtime resident on Alciona Drive in the Hollywood Hills. I'm a proud member of the Hollywood Dell Association, and today wanted to give a shout out to the horrible board on Cahuenga, just north of Franklin. When the board was put up over a year ago, our group was out there with our signs the day after, because everyone in this room knows what Cahuenga and Franklin is like. There are no left-hand turn signals at any north, eastbound, or west, and this board, aside from throwing the light to our dear neighbors, to the point of so many people getting ill behind the sleeplessness that the light causes, I'm well aware that there are contracts involved, and we have two companies, billboard companies in the room, including CBS, whose board that is. But we just want to talk about the difference between, or bring the energy and attention to the illegality of these contracts. And I think that triggers concern for the companies that know they need to review these contracts, get it right.
Thank you very much. Michael McHugh and Dan Silva.
Good afternoon, Chair and members. I'm Dan Silver, Executive Director of Endangered Habitats League. We're Southern California's only regional conservation group. I'm also a lifelong Angelino. We must all be urbanists. We're here to defend the quality of our public spaces, our streets, our sidewalks, which have been horribly degraded by these digital signs. The agreement has now been shown to be illegal from the outset. We have an opportunity to fix this horrendous problem, and we urge you to move forward on the motion. Thank you.
Thank you, sir. Now we'll hear from the council representatives from the following districts. We have Wendy Blumenfeld from Councilmember Bill Rosenthal's office, Sean Bonas from Councilor Paul Koretz, and then we'll have last Kathryn from Council District 13. Good afternoon.
Good afternoon, council members. I have Whitney Blumenfeld for the record for Councilman Bill Rosendahl. Councilmember Rosendahl believes that the settlement agreement was unlawful and that converted billboards should be returned to their original state. However, the councilman also understands that we must develop an administrative and regulatory scheme that is consistent as we move forward, and therefore he supports the adoption of the Garcetti and Reyes motion and looks forward to report back from our city agencies. Finally, the councilmember believes that any administrative process of permit revocation should be undertaken by the council and the burden not be placed on our community to appeal each and every permit on a case-by-case basis. Thank you very much.
Okay, before we ask the next councilman office, we might have looked over one person, Ms. Charles.
Good afternoon, Tracy Shavira, Central City Association.
I'm sorry, I'm blind at this one.
We believe that it's important to create an even playing field in the city so that our policymakers can craft a comprehensive ordinance that reflects the need to boost our alien economy and protect our neighborhoods. CCA respectfully requests that you also remain mindful of the distinction between on-site versus off-site sign issues. Businesses survive or fail depending on their ability to promote their goods and services effectively. And the most cost-effective way of doing this is through on-premise business signage. There have been no new restrictions relating to on-site signage, yet significant delays still remain in obtaining permits. These delays impede the city's ability to generate new revenue and are yet another disincentive to doing business and creating jobs in Los Angeles. We respectfully request that you take measures to remove roadblocks in the issuance of appropriate on-site sign permits in the city. We also respectfully request that you schedule an update regarding on-site signage issues. Thank you.
Thank you. Okay, now we'll have Sean Bayless.
Sean Bayless, Councilman Paul Koretz's office. I've submitted a joint letter signed by both Council President Eric Garcetti and Councilman Paul Koretz. I'd like to touch on just a couple of issues. The removal of the digital signs that have been erected due to the unlawful 2006 agreement must be paramount. We therefore believe that it's critical that the Building and Safety Department immediately develop procedures to review the ongoing legal status of previously erected digital signs. We question how any of these signs causing blight to our neighborhoods could be allowed to remain, but consistent with the decision of the Superior Court, we believe that signs must be reviewed through some administrative process. We believe that the city should not pursue any appeal to the Superior Court ruling invalidating the 2006 2006 settlement agreements and instead should embrace the opportunity this outcome now affords our city. We therefore urge your committee to support the Councilman Garcetti and Councilman Reyes motion before your committee today, with the amendment that the committee instruct the city attorney to take no appeal of the Superior Court decisions in the underlying litigation.
Thank you, sir. Last but not least,
Kathryn Hennigan on behalf of Council President Eric Garcetti. Good afternoon, Plum Committee members. Over the last several years, we have all seen how visual blight can have a negative impact on the way neighborhoods look and feel. Our office routinely hears from a large number of CD13 constituents about their disapproval of digitized billboards in their neighborhoods. Through various court decisions, the city has learned that numerous permits issued under settlement agreements with major sign companies have been unlawful, and many have been rescinded. These permits are invalid and contrary to public policy. We request that the Department of Building and Safety revoke permits issued during the settlement agreements entered into between 2005 and 2007 with the 4 major outdoor advertising companies, if in fact these permits are unlawful, invalid, and unenforceable. We ask that you instruct the city attorney to include a response to our motion within their report on the Summit Media case and urge you to support our motion before your committee today. It's now time for these frivolous lawsuits to end and for the city to take action on the issue of off-site signage. We can and will find an effective way to regulate the visual atmosphere. We have an opportunity to work with the billboard companies, looking towards the future and mapping out fair and appropriate places for digitized signs. Thank you.
thank you very much, and that closes the public comment on this item. Colleagues, I'd like to move that we adopt with the understanding that we ask that this motion be part of the report from the City Attorney's Office regarding the Summit Media case, so that it all comes together given the significance of these issues. Any comments?
Yeah, is the City Attorney's report coming to Plum or is it going to full council?
My understanding that it's coming to Plum.
Okay, well, instead of adopting this motion as written, why don't we continue it so that we don't take a position that may be contrary to anything you might want to take when we get full information from the City Attorney's Office. We may want to amend it because if we adopt this now, we may get new information from the City Attorney's Office. We may want to change it. So I would suggest that we continue it and then take it in with the City Attorney's Office next week.
I'm very flexible.
Yeah, with
listening to my attorney colleague here, Councilmember.
When I look at the motion, it begins in a prior settlement agreement with various billboard companies, naming those companies, and has received testimony from both sides of the fence, those that support, those that don't support the business community, etc. What troubles me is if we make an agreement to do something, we should have some credibility, and we have some ability to stand up for what agreements we make. And if we make agreements that aren't appropriate, then we should admit that we've made those inappropriate agreements. But what we have in this particular case is a settlement that was done in closed-door session without input from the public, which a lot of people view as a sweetheart deal. We're supposed to be an open, transparent government, and I find this disturbing to the business community, those that have testified from the billboard industry, those are the community members that have concerns with this. I had concerns when it first took place, but what troubles me most is when we betray the public, when we deceive the public, when we're not credible with the public, it destroys democracy and the foundation of this government, and I find that very disturbing. And I agree with my colleague, Mr. Huizar, that we should continue this matter. We should do additional follow-up on this. But for the community groups, I understand, I empathize with you. I know the impact it has on communities, and I also understand business and how business is struggling for survival. Not that the billboards are going to help the businesses to that great degree, but oftentimes a deal is a deal, but when the deal is done in a closed-door session, it seems deceptive. So obviously the court has ruled, we have to take that in consideration, but I think the whole deal has a bad taste to it for all parties involved, the residents, the community, and
the billboard companies. I don't think there's any winners when you really look at this situation and how it transpired. So I would recommend, along with my colleague, Councilmember Weezer, who is a scholar of law, unlike our planning director, Mr. Ed Reyes, and me, the cop on the beat.
You don't want to go there, do you?
Yeah.
I was responding to you now.
The planning director.
Okay.
I don't fault anyone. I don't fault anyone here. I'm just saying how this whole incident transpired over the time, and listening to the testimony and paying attention to that testimony, I think it'd be appropriate that if we did, as Mr. Weezer suggested, for the benefit of everyone involved.
I just want to be clear, my colleagues. My intent is to have the instructions in the motion be part of the report. Now, if continuing this allows for that directive, then I'm fine with continuing it. And so I want clarity from our advisor as far as the intent of the motion is to follow the instructions that were submitted. The instructions, can they be followed as part of the report back with the Senate media case?
Jerry Burge, City Attorney's Office. If you continue this matter in Plum, we will certainly address the issues in this motion in our report, whether you would continue it or adopt it. Either way.
Okay, that would be the priority, and the intent of the motion is to follow these instructions as stated in the motion, and I'll be fine with continuing this because of the legalities of what Councilman Rizal mentioned. Councilman Rizal?
I have one more point. I see in the audience Jane Usher, who's with the City Attorney's Office, and invite if you have any comments. I know that you have a lot of expertise in billboards. Any comments on this particular subject?
Councilman, thank you. I hadn't intended to speak today. Jane Usher, City Attorney's Office. The City Attorney's Office has begun its review. We've read Summit Media's materials. We've read CBS Clear Channel. We've looked at this motion. The motion will not be contradicted by advice of the City Attorney, so you could act on it today or you could wait.
Okay, thank you. Thank you.
And if I could also add, Jerry Burge for the record, another option I think would be if you wanted to refer it to Building and Safety as well as the City Attorney with a report back at the time of the closed session matter.
Yes, and I think that covers all the different bases. That was the intent of the motion, and I appreciate that advice. Okay, so we will continue with the instructions to both Building and Safety and City Attorney to review the directives and to essentially maintain the intent of the motion, and we'll have all motions together when you come back with a report from the Summit Media case, and now the action of this committee. Do you have anything else you want to add? Okay, that will be the action of this committee. Roberta, what's the next item?
Council member, the next item is item number 4, which is communication from the Planning Department requesting authority to execute 7 Mills Act historical property contracts.
Okay.
Yes, Lambert Giesinger, Historical Property Contracts Manager for the City of Los Angeles. There are just 2 minor amendments to this report since it was prepared for the committee. One applicant has voluntarily withdrawn the application for 256 South Van Ness Avenue, and 4 applicants did not successfully pass the pre-contract inspection, and they will be allowed to petition the Cultural Heritage Commission on December 3rd to appeal the staff determination of ineligibility, and based on those findings. And what we ask is that the council approve a clearance for 69 applications in this case, with the 4 in question subject to the final decision to execute by the Director of Planning. Thank you.
Okay, so those technical changes have been submitted?
Yes.
Okay, and we can move the report? All right, so now the Actions Committee to adopt the communication from the Director of Planning relative to a request for authority to execute 70 Mills Act historical property contracts.
Thank you.
Thank you, sir.
Council member, did you have speaker cards on this item?
You know what? I did not.
Okay, I thought you did. Okay.
Thank you. Those on the board. Next item, sir.
The next item, Councilman, is item 9, which is a report from the Planning Department. It has to do with a general plan amendment and a vesting zone change for the construction of 482 residential units and commercial uses in CD4.
Good afternoon. Henry Cho of the Planning Department. I am also the hearing officer for this case. What we have before you is the Wilshire La Brea project, mixed-use project, 482 residential units and 40,000 square feet of retail. The project is located on the intersection, the southeast corner of Wilshire and La Brea, and it's also at the intersection is the future location of the Purple Line station. The applicant has worked with the community to revise the project and design the project to be compatible with surrounding developments, including residential neighborhood along Sycamore Avenue. Just a few items. CPC held its meeting on August 13 and approved the project and adopted the EIR. No appeals were filed. On September 1st, the City Council adopted a resolution to forward comments to the California Register opposing the Los Angeles Conservancy's early nomination of the Columbia Savings Building. Staff has also submitted updated CEQA findings and understands that City Council office has submitted conditions of approval, and staff has reviewed that and has no problems with that. So staff is available for any questions. Thank you.
Thank you very much. Now, can I just ask you one question? So I want to put this project in perspective. When this project started, what was the entitlement capacity of this site? In terms of height?
It had unlimited height, and from what I remember, the original proposal was about 17 to 18 stories. And the project has worked with the community to shave it down to 6 stories with a mezzanine above.
And the original project introduced?
They had something like 700 residential units proposed.
And you're down to what?
And it's down to 482.
Okay, I just want to put in perspective.
Okay.
Okay, that being said, I'd like to continue with speaker cards. We have Dale Goldsmith, Mike Bruner, and Dan Silver.
Good afternoon, honorable committee members, Chair Reyes. Dale Goldsmith with the law firm of Armbruster, Goldsmith & Delvac, representing the applicant.
Can you just hold on for a second?
Sure.
This will close public hearing, no more cards, and any other cards that come in will be part of the record. Thank you.
We have here the full development team today. From BRE, Steve Dominiak, Dave Powers, Jeff McNutt, the project architect Daniel Gaiman, the historic preservation expert Robert Chattel, and my partner William Delvac. We would be prepared to give you a project presentation, but given the late hour and the fact you still have a number of items, I'm prepared to just make some brief remarks and hand it over to the next.
Why don't we do this? Why don't you do just a brief summary of the project, and I'd like to hear from the other folks who submitted cards, and based on questions and issues raised, if we have questions, we can point to a more thorough presentation.
Okay, thank you very much. The project, as Mr. Chu mentioned, is a mixed-use, transit-oriented development located in a regional center adjacent to existing bus lines and a future subway station at the corner of Wilshire and La Brea. The project will provide an easement to the MTA to allow direct connection from the new subway station to the project should the MTA so desire. In addition, the project will incorporate sustainable design features and is targeting a LEED Silver status. As Mr. Chu mentioned, the project has been working with the council office, Renee Weitzer, and the community for a period of approximately 3 years. Based on their input, this project has evolved from an original almost 650 units, a 5.4 to 1 FAR, and 14 stories to the currently proposed project of 482 dwelling units, 3.3 FAR, and only 6 stories. So it's really evolved quite a bit based on that public input. In addition, the project includes a number of public benefits that we've negotiated with the council office and the community. These include a publicly accessible pocket park at the corner of 8th Street and Sycamore, implementing neighborhood protection measures amounting to almost $400,000 to address existing cut-through problems. The project itself will not have any such impacts. In addition, the project will incorporate innovative measures to reduce vehicle trips, including a parking opt-out for tenants who decide they don't want to have parking spaces and want to use alternate modes of transportation. They will get a reduced rent, transit passes for both workers and residents, and ample bicycle parking. In addition, the project will provide wide tree-lined sidewalks around the entire superblock. It represents an entire block that will promote walkability.
The project also enjoys quite a bit of public support. I have some letters here that I'll submit for the record. In addition, there were a couple of speakers who were going to speak today, but due to the lateness of the hour, had to leave early. But I'm happy to say that the project is well supported in the community, and thanks to the council office for helping us come up with a project that was able to win their support. BRE, our client, is prepared to invest $292 million in shovel-ready funds. This project isn't a concept, it will be a reality because BRE is prepared to fund and start construction as soon as we get approvals. The project will create approximately 800 full-time equivalent construction jobs and 134 permanent jobs. We respectfully request your approval, and we'd appreciate the opportunity to provide a rebuttal at the end. Thank you.
Thank you, Mr. Goldsmith. We will start with Joyce Clayfield. Ira Dankberg.
Good afternoon.
Good afternoon.
My name is Joyce Clayfield. I'm speaking in support of this project, both as a longtime resident of the City of Los Angeles and as the community representative for and Director of Development for Fairfax High School, which is located in the historic Fairfax district of Los Angeles. Fairfax High is a traditional comprehensive high school serving over 2,500 neighborhood students. I met the applicant at a community presentation of his project, at which I was most impressed with the conscientious attitude of the developer and the aesthetic appeal of the project. I introduced myself as a representative of the high school who is working to connect the school with its community and to build partnerships to allow opportunities for our students. The developer totally embraced our school and its vision and has provided invaluable support in our fundraising and community building partnerships. More importantly, they're interested in maintaining a relationship with the school and its students and providing opportunities for our students. The project is worth supporting on its own as a major improvement in the community, but I also believe we should encourage this type of community consciousness by supporting this worthy project. Thank you.
Thank you, ma'am. Yes.
I have a question for the lady. Ma'am,
Yes,
this project's at Wilshire and La Brea,
Yes, it is.
and Fairfax High School's at Fairfax and Melrose.
Yes.
Does the relationship extend to LA High School or Hollywood High?
I'm not a representative of Los Angeles High School. I'm specifically attached to Fairfax High School.
I understand. I'm just trying to find out if they're assisting other two high schools in that neighborhood, LA High on Olympic Boulevard and Hollywood High on Sunset Boulevard, since it's kind of like a
I think Mr. Powers
triangle.
could probably address that better than I. I specifically reached out for Fairfax.
that's a pretty good question for Ms. Weitzer, too.
Did you make the contact with them, or they make the contact with you?
It was a mutual contact at the at this community meeting.
All right, thank you.
Right, okay. Charles Fisher, Regina O'Brien, Sharon Eastman, and Annie Morrissey.
Good afternoon. Charlie Fisher, 140 South Avenue 57, Highland Park. And I'm speaking not to oppose the project. I think this sounds like it's a good project in many respects, but we need to step back and look at what is being lost. And what is being lost is one building in particular on the corner, the Columbia Savings Building, which is a mid-century modern bank building. It's a very unique structure and very emblematic of the design that was coming to Los Angeles at a time of a very bright period of growth. We're asking, since this building is before the State Office of Historic Preservation, before the State Board coming up in January, that the approval of the EIR be delayed until the State Board can make its decision. Because at this point, the EIR document is showing this building as not historic. And yet the decision made by the state could very likely change that status. We are asking, therefore, that the approval be delayed until the State Board has had a chance to make its determination if this building is in fact a state historic resource. Thank you.
Thank you, sir. Our next speaker, please. Regina O'Brien, Sharon Eastman, and Annie Morrissey.
I'm short. Hi, I'm Regina O'Brien. I'm the chairperson of the Modern Committee of the LA Conservancy. How many people here have seen the Columbia Savings Building or been in it? To me, it seems a little crazy to vote on the merits of a building that few are truly familiar with. However, I know this is not your job, but then shouldn't we defer to the professionals in this matter, the State Historic Resources Committee? Please postpone your vote until they have considered the nomination for this building. I've seen the renderings for the proposed building to be built. It attempts to be all things to all people, townhomes facing Sycamore, Deco by the Firestone building. On the corner, the architects proposed to mimic a historic tower from a building down the road. Instead of not original architecture, reproposed architecture, why not keep the architectural gem already on the corner? It could be a wonderful restaurant, it has a beautiful stained glass ceiling, and could provide the very mixed use that the project wants to build. Please give this building a chance by postponing the vote and considering adaptive reuse. Aside from being the chair of Modern Committee, I'm also a constituent of Ed Reyes. Thank you.
Thank you, ma'am. One of my bosses. Come on up now.
Hi, I'm Sharon Eastman, and I'm a resident of the Miracle Mile area, and I'm also...
Into the microphone, please. There you go.
Okay. All right. Can you hear me better?
Yes.
Okay, thank you. I would like to move to also oppose the new development at this location because, well, I did speak a few months ago at the Historic Resources Committee board about the merits of this building and why it should be considered a historic landmark. And this is why I move that you postpone the vote on the EIR until after the January hearing. It's also, I mean, that Columbia Savings Building, it's a grand space. It's monumental. I mean, you enter it. I haven't entered it, but I want to enter it. I've seen pictures, but, you know, I've entered into this space, and it's magnificent. And it'd be just a shame to see another gem of Los Angeles architecture to be just torn down to put some historicist pastiche-type new development that isn't really of the moment. It gives a little bit of a reference to Deco. It gives some townhomes, a little bit for everyone. But, you know, if you're going to build something today, build it of today so we know it was something that was built in 2010. Don't give me a pastiche of old styles that are soon all going to be torn down. That's kind of ridiculous in my opinion. And, okay.
Thank you, ma'am. All right. Annie Morrissey, Marcello Vivala, and Ira Dankberg.
Good afternoon. My name is Annie Morrissey, and I'm a member of the Los Angeles Conservancy's Modern Committee, as well as a resident of CD1. So I'm also one of your constituents, Mr. Reyes. I'm here today to ask you to postpone the vote on the certification of the final EIR. The Columbia Savings Building is one of our best, most intact post-war bank buildings, and it really deserves to have its nomination considered before the State Historic Resources Board. Following that, it ultimately deserves to be preserved and adaptively reused. It's an amazing candidate for adaptive reuse. What I personally love most about this building is its unusually tall signage and the large abstract art pieces. I'm not opposed to development on this site. In fact, I think it would be great to give new life to this building and allow the public to experience it, because currently it's all closed up. We can't see the great stained glass artwork in the ceiling. You can't see it from the exterior, so it would be great to see this adaptively reused. And in closing, I urge you to postpone the vote in order for the nomination to be heard. Thank you very much.
Thank you, ma'am. Marcello Vivala, Ira Dankberg, and Bill Bergstrom.
Good afternoon, committee members. Marcello Vivala with the Los Angeles Conservancy. While the EIR finds that the Columbia Savings Building is not a significant resource, several experts, including architectural historians who specialize in modern architecture and post-war resources, have provided strong evidence that the building is indeed eligible for listing in the California Register. The prepared nomination, which is a collaborative effort between the Conservancy and Historic Resources Group, combines exhaustive research, interviews with experts, authors, and architectural historians, and original survey research to thoroughly examine how this building fits into the context of and exemplifies post-war bank design in Los Angeles. The State Historic Resource Commission's vote on the nomination, which represents the most thorough examination of the bank's significance as a historic resource to date, should be considered as the final word on whether this building is indeed a historic resource. The architectural history of LA is filled with numerous examples of significant masterpieces being demolished before their true value could be understood. Let's not let that happen to this Wilshire Boulevard icon. I urge the committee to postpone a vote on the EIR until after the State Historical Resources Commission has voted on the nomination. Thank you.
Thank you very much. Bill Bergstrom? Bill here? Okay. Charles Cordero? Don Silver?
Here comes somebody.
And Mike Bueller.
Cordero?
Sir, come on up. Good afternoon.
I'm Charles Cordero, and I'm a resident of the area. I'm also an architect, and I grew up in the area, Miracle Mile, Hancock Park area. I've been in the area for about, I think, 45 years now. So I kind of know the site really quite well. And historically, it's, I'm not going to sort of focus on the sort of the merits of the design of the new structure. I'm going to concentrate on the merits of the urban attitude that it's creating. It's very urban in the sense that it's next to, obviously, the new transit station for the metro, as well as major transit lines along Wilshire and La Brea. But I wanted to just point out, because there's been a lot of focus on the existing former bank building there and its value. I would just like to say that perhaps the notion of mid-modern century is somewhat of I would say, sort of a catch-all phrase. But what I think you need to look at is the exact value of that building, as it exemplifies a sort of disdain for an urban building. And I'll just point out two things. That area was actually, the Miracle Mile area was built for automobiles, essentially, and that building is, I would guess, be the high point of automobile-oriented development, in that the large pylon signs on the building that are I think it's the largest element on the building, they're over 100 feet, close to 100 feet tall, are meant to be seen by cars traveling at speed down the boulevard. They're not meant for pedestrian usage. Also, if you look closely at the building, it's on a raised podium, which precludes sort of an urban interchange between the interior and the exterior of the building, which the new building actually exemplifies. So I just think it's a bad example of planning policies that were exemplified in the 60s era that have been debunked.
Thank you, sir.
Thank you.
Dan Silver and Mike Bueller. Are you there?
Good afternoon, members of the committee. I'm Mike Bueller, Director of Advocacy for the Los Angeles Conservancy. I also live at the corner of Fairfax and Olympic, very near the proposed project. The Conservancy urges you to defer action on the final EIR for the proposed project until the nomination for listing in the California Register is considered by the State Historical Resources Commission in January. This nomination was submitted only after long-standing good faith efforts by the Conservancy to establish the significance of the Columbia Savings Building during environmental review for the proposed project. Our conviction that the building is a historical resource under CEQA was originally detailed in a 14-page comment letter on the draft EIR over a year ago. Given the level of documentation submitted on the building's significance, we were surprised that the responses to comments in the EIR refused to acknowledge the significance of any aspect of the building. Even the building's spectacular 1,300 square foot Dow de Verre stained glass ceiling is described as unexceptional. Because evidence of historic significance is largely dismissed in the EIR, the Conservancy retained Historic Resources Group to prepare a California Register nomination for the building in an effort to resolve its historic status under CEQA and to ensure consideration of alternatives through the EIR process. Significantly, the City's Office of Historic Resources was not consulted on the building's potential significance during the EIR process, with the EIR's conclusions based solely on reports prepared by consultants representing the project applicant. When the nomination did finally come before the city's Cultural Heritage Commission, it's notable that the commission voted 4-1 to approve formal comments recognizing the significance of the building's art program, quote, as a fully realized example of post-war American bank architecture representative of national trends during that era. It's important to reiterate that the Conservancy is not opposed to proposed development on this site. We merely want to ensure consideration of alternatives.
Thank you, sir. Thank you very much. So I believe we covered all the cards on this item, except for Councilmember Representative Renee Weitzer. And
thank you very much, Mr. Chairman, members of the committee. We are in great support of this project. We believe that we have a fantastic project. We've worked with the community for 2 years on this project and have come up with all of the conditions. There is no community members that came today that oppose the project. We do not support the designation of this building, and I believe the council voted unanimously not to support a designation of this building.
now, I know, how can I say this?
Say it any way
In
you want.
terms of its presence in the development, is it in a key location for this site?
As far as you're talking about the bank building?
The bank building.
We don't feel that the bank building, is deserving a designation. Is that what you're asking?
Yes.
No, I believe that if you preserve this particular building, the whole project is dead.
Okay, that's key.
It's an entire block. It's an important corner of La Brea and Wilshire. It'll be an icon on the corner. It's across the street from a Subway location. They're doing a portal. We have all of the conditions, and if this is not, if the building is designated, then the project is dead.
Okay. Any questions for Ms. Weitzer?
Well, I have a question regarding the historical value. Has that review been complete by the City of Los Angeles?
Yes, they have not applied to the city for historic designation. They've applied to the state.
And that has,
So it
that has
never
not
went
been,
through our cultural commission.
that has not been completed by the state review.
No, and there's no timeline for the state to review this. So it could be next year, it could be, 6 months. There's no, they don't have a timeline for this.
When do they plan to start construction or demolition?
They plan as soon as they get approval. They have the money to go forward with the project. They don't need any loans. This company keeps its buildings. They don't sell them. It's all apartments. It's all rentals. It's not a condo. And basically, they're ready to go.
Are the rates workforce on the rentals? Or are they market
Can
rate?
you answer that, Dave? Excuse me.
Thought you would have thought about that one.
Beat me to the punch, Dennis. You beat me to the punch. That's good.
I'm sorry.
Well, I'm glad you did.
Once again, for the record, Dale Goldsmith. There'll be a variety of unit types and sizes ranging from studios to more family apartments. Beery has not set the rental rates yet because it's going to be at least 3 years into the future before that happens, but we would anticipate that the rental rates will reflect the demographics of the surrounding area based on the various unit types.
Well, that tells me it's market rate. Market rate is much different than the
They will
workforce.
be market rate, but the thing to keep in mind, Councilmember Zine, is that there'll be different sized units, and because the rental rates are based on square footage, there'll be some units that are more affordable for kids fresh out of college or their first job, while there'll be other ones, larger units for people with families, maybe dual income, that will be able to afford more.
Well, the problem that I have with that is that unless there's a rate for the working class along Wilshire Boulevard, retail stores, restaurants, etc., that are in a lower economic environment, they don't have the opportunity to live in that type of building. It would be folks that are in a profession that gives greater compensation, and the concern is for workforce housing for teachers who are getting, I think, a 12% pay reduction, or firefighters, police officers, etc., or the working class that would serve the folks in that community versus the higher end, which can afford it, where they have more spendable cash. So workforce housing is one matter that this council has been very supportive of. I know another project on La Brea and Willoughby that was discussed in council where the developer did agree to include workforce housing and I would be resistant to not urge in some type of an agreement that workforce housing be included, whatever percentage would be appropriate to help the working class of society that doesn't have money to live in an area where they work, where they have to then commute greater distances. That's a concern that I think this entire council has.
If I may respond briefly, just again to reiterate, Councilmember Zion, there'll be a wide variety of different sizes of units. The smaller units will be affordable to working people just because they're small.
Affordable?
But I also want to point out that the
Mr. Grossman, can I ask you a real direct question?
Yeah.
How do you define affordable?
Well, they will not be deed restricted if that's what you're asking, but I want to reiterate, this project started out with 640
You're still not
units.
answering the question.
The units will be market rate units, but the smaller units will be within the ranges based on where market rate is today that will be affordable.
So give an example of what is market rate at the lower end from your point of view.
I'll pass it over to the Dave Powers of BRE.
Hi, Dave Powers, the BRE Properties. We're the developer on the project. The units in this project range from about 450 square feet all the way up to about 1,350 square feet. So it's a broader range. We have smaller units in this project than we have in other projects. Given current economic conditions, I mean, we have a project down the street that finished lease up recently, and I think rents there, if we were to open today, rents would range from, I'm going to say $1,300 on up.
So $1,300 a month for a 450 square foot unit.
Yes.
That is not affordable.
As I was saying, and as Mr. Chu said and Renee said, this project started at 645 units. With a project that size, there probably could have been an affordable component, but we heard from the community, we heard from the council office, there were great concerns of density. The project has gone down from 645 units to 482 units. In addition, the direction we got from the council office is that what the community was looking for were some traffic improvements. They wanted a pocket park, and the project accommodated those. At this point, and in this environment, the project is viable, but one more straw will break that camel's back. This is a shovel-ready project, ready to create 800 jobs. The client is willing, ready, and able to go for it, but given where we were before and where we are now, we can't give any more.
Well, at 450 square feet, how many people can you put in that?
Those would be studios.
Studios, that'd be one person.
Yeah.
And a person who's working as a laborer, $1,350 is much more than he could afford, and we're talking workforce housing, which would be a much lower rate. I understand how you're trying to satisfy the community.
Yeah.
The obligation we have is to satisfy the folks that are living in Los Angeles and want to live in a comfortable environment. They're not Section 8, they're not on welfare, they're earning a living, but they're not earning a living that would provide them that type of ability for rent at $1,300.50 for a studio apartment. I have some real problems with that particular aspect.
Well, and I appreciate it, but again, I want to reiterate, the project has been substantially reduced. We've been working for 3 years with the council office. We've put a lot of public benefits at the council office's direction, and this is where the project is today. We're very proud of the project. As you can see, the community has not come out in opposition. The earlier hearings that happened, this is a good project. It's a transit-oriented development.
Is this in the CRA area?
No, it is not, sir.
Okay. Have you spoken with the housing department for any kind of resources that would allow for workforce housing to exist in this facility?
We have not had those discussions, but Chair Reyes, we would entertain discussing that with them, provided that it wouldn't jeopardize the financial viability of the project.
What's your deadline in terms of making a decision in this case?
This project should have been built a year ago. We've been caught up in a long process. BRE has funding today, but the capital markets have been so crazy, I can't tell you that the funding will be there next week, Chair Reyes. This is 800 construction jobs at a time of unprecedented unemployment. The city needs that, and we need to get moving forward. Any delay jeopardizes this project. Thank you.
Madam Attorney, Madam Clerk, what are our timeframes for making a decision on this?
Jerry Birch, City Attorney's Office. According to your agenda, the time limit is January 20th, 2010, so you can continue this item without consent of the applicant.
Okay. What I'd like to do, Ms. Schweitzer, is continue this week, 1 week, with the understanding that we get some feedback from the Housing Department to see how we can address the goals of the city in providing housing for the people who live in the city. As been stated by Councilman Zine, the vast majority of the people that are living in the city do not and cannot afford this rental structure. But if we provided the Housing Department opportunity to visit this project, perhaps we can create opportunities in the future on this site if you give us 1 week.
You're the chairman.
Well, that's what I'd like to
I would
do.
prefer, of course, we would prefer, of course, that you support the project and, move it on to the council. Can we vote on it today and move it on to the council and then come back with that issue in full council?
Well, the problem with that is that we don't get this kind of discussion at this detail in council. And so we will continue 1 week if we get that feedback from the department and see how we can essentially structure, if possible, knowing what condition the city is in with its resources, and see if we can fit that in, and we continue this 1 week, then we'll take a vote.
I do want to say one thing that, when we began to work on this project 3 years ago, this really was not a focus, and I have to admit we didn't, work on that, and we just really tried to go with the neighborhood to reduce the project because nobody wants anything today, and it's a major corner, and we thought that we had a developer that was ready to go and willing to do all the amenities, so we didn't really address those issues at that time. I have to, be honest and say that.
Again, this is not a negative reflection on anybody. It's a real concern. It's been brought up by the committee. I agree with Councilman Zine. It's something I've been saying over and over again. I've been a broken record on this issue.
Right.
And I do this every opportunity I get. And as you said, as chair of committee, I would have that discretion. So if you allow us 1 week, that's the direction we'd like to go. And hopefully they won't create much more of a hardship on the development.
I just want to add, and I need to put this on the record, that we had a project in my district in Warner Center. And Warner Center is an upscale community in the Woodland Hills area.
Familiar with Warner
where we had a large development, and we pressed for 25% workforce housing due to the retail in that particular community, Sears and Roebuck, Target, Home Depot, etc. And the developer put in 25% workforce housing so the folks that work there can live in that community, along with the folks that work in other areas, lawyers and other professionals that receive much greater compensation can also live in that area. So we put a condition in, and Mr. Reyes, I want to commend for being sensitive to the workers of the city to give them quality, affordable places to live. But at $1,350 a month for a 450 square foot unit, a single studio, that is prohibitive for many workforce people in the city of Los Angeles. So I would say that we've done it in my district in Woodland Hills. I think we need to do that citywide, and I think that would be a message to developers that you need to consider the folks that are working that aren't receiving great compensation for what they do for a living. Thank you.
I do remember that case.
Thank you, Councilman Zine. So we'll continue this 1 week.
Thank you.
Thank you. And perhaps if my staff can follow up with you, Ms. Schweitzer, and the developers of the Housing Department, and see if there's an opportunity there. Thank you. All right. Next item.
Next item, Councilman, is item 10, is a Planning Department report and an appeal by CNS Shaw Family Trust, and they're appealing the disapproval of a general plan amendment and 2 zone changes for the construction of 10 townhomes in CD7.
Okay. Good afternoon, sir.
Good afternoon, Councilman. Tom Glick, City Planning Department. I'm going to be really brief on this because of the time. This project is located in Paramount City. It is a through lot. The applicant requested for 10 units, RD3 over the entire site, and it needed a plan amendment to low, medium 1. Planning Commission, and if you actually have gone, if you go to the site, it's a through lot into a single-family neighborhood. What made it unique was there were 6 ad areas included. Council office could not support the addition of the ad areas, so a compromise was reached. Planning Commission, in essence, recommended approval of the zone change along Woodman, which was the secondary highway, and then disapproval of any plan amendment or zone change within the single-family neighborhood. So that's, in essence, Planning Commission's action. But I believe Council Office is going to come up here today with the applicant and put forth an alternative which the Planning Department would support. So.
Okay, so it sounds like you reached some kind of compromise here?
Yes.
Okay.
But I'm going to let the applicant in the Council Office.
So we have an applicant here, Mr. Michael Ramirez.
Good afternoon, sir.
Hello.
Chairman, committee members. The request before you is basically to support one portion of our previous application was approved, the RD3 on Woodman, so we're going to request that you support that. We've since asked for a zone change to RE11 on the Moonbeam side to stay conforming with the rest of the neighborhood, and additionally just to move the boundary line adjustment for the RD3 portion that was approved.
So you agree with the compromise?
Yes, sir.
Okay. Mr. Faisal Al-Sari?
Hello, good afternoon, council members. Faisal Al-Sari with Councilmember Alcone's office. Just here to be very brief and relay the council member's support for the applicant's request. This will address the neighborhood and community concerns while advancing the goals of the community plan and what the CPC originally envisioned. Thank you very much.
Okay, so we can move this with the instructions for, I don't know if there's appropriate language for this.
I guess that would be to direct planning to draft findings to support the request and send this on to full council.
Yes, and Jerry Burge for the record, and this would be a grant of the appeal.
Okay.
And approving the plan amendment and zone change as described by the applicant and asking for preparation of findings of planning.
Okay, so you just summarized a 10-sentence paragraph I was about to engage in. Okay, it's okay. I'm glad you did. Just following instructions, yeah. Okay, so colleagues, can we move on that item? All right. And I think that'll be the action of this committee. And next item, Roberto.
Council members, item 12 is an appeal by Deborah Callow and Vincent Comparsi. They're appealing the action of the zoning administrator as it relates to a nuisance case in CD 15 for a business known as Village Pub.
Good afternoon. Again, Sue Cheng with the City Planning Department. This is also, again, subject application is to abate nuisance activities associated with a cocktail lounge known as Village Pub in San Pedro community. There have been allegations of repeated nuisance activity at the club. The samples of those complaints are excessive noise from playing a jukebox and live entertainment, smoking, vomiting, vandalism, and fist fights at the club. The pub customers blocking the walkways, sitting on the staircase while smoking cigarette pots, and engage in loud and obnoxious conversations. Smell of smoke and marijuana in the walkways and through the windows. Litter and trash on and around the site, such as beer cans and cigarette butts. Beer bottles filled with urine in the patio of the adjoining tenant. Motorcycle parking anywhere on the site, including the walkways. Loitering, public urination. Sometimes the tenants in the shopping center find human feces on the patios of the adjoining tenants' space, intimidating customers and employees in the shopping center, verbal and sexual harassment by the bar patrons, drunk patrons involved in an altercation with the LAPD officers who are investing the LAPD activity on the subject location.
Public drunkenness is a daily occurrences around the lounge. Possession of illegal drugs, battery, fights in the bar, shooting incidents, those things are all reported at the testimony at the hearing conducted by the zoning administrator. This bar has been also known for a hangout place for gang activities in this area. In addition, Village Pub has been violating the rules and regulations relating to the sale of alcoholic beverages. The sale of a full line of alcoholic beverages at the Village Club was permitted by the prior conditional use permit, which was granted in 1998. The conditions required no pool or billiards table, no jukebox or coin-operated game machines, no entertainment, no live band. This bar had them all. There's a blatant violation of the prior conditional use permit. Also, there are some ABC regulations in violation. Sale of alcoholic beverages to minor. Customers are allowed to drink alcoholic beverages outside the premises. Possession and sale of contaminated alcoholic beverages at the bar. After the determination on this case was made, condition number 20 specifically requires no access door is permitted for patron access, and it shall be kept closed except for emergency access only. The zoning administrator received complaints from the tenants in the shopping center. The rear door still kept open. Patrons hang out in the backside and smoking and do normal things. They complain about operation of this bar. In order to mitigate nuisance activities, 29 operating conditions are imposed by the zoning administrator on behalf of the Director of Planning. You have two appeals before you. The property owner, the owner of this shopping center, is appealing the entire decision of the Director of Planning, and also business operator is appealing the decision. The property owner asserts that the implementation of the imposed conditions should be responsibility of the business operator, not the property owner. Therefore, the condition number 1, which requires recordation and covenant and agreement on the property, shall not be required. And also, business operator feels that the imposed conditions are onerous and cause a hardship on viable operation of the business. Specifically, condition number 17, that requires a designated driver program. The business operator feels that that is only applicable to the restaurant and should not be really applied to the bar operation. Condition number 23, which requires a security guard during operating hours. Business operator wants to provide one security guard only during weekend days after 9 p.m. Condition number 1, that requires a covenant and agreement. That's the standard condition city requires for all discretionary actions. That's the only way city makes sure that those imposed conditions are in public records, so future property owner or business owners are aware of such imposed conditions. And I strongly feel that that still should be imposed as part of this application determination. And also, business operator would request a one guard just for the weekend after 9 p.m. because the criminal activities occur late at night on weekends. I dispute that reasoning. The security guard is not required just to deter criminal activities. There are nuisance activities associated with this bar operation, such as the pedestrian or the shopping center patrons are harassed by these patrons and the walkways are blocked. I have report from the tenants in the shopping center. The nuisance activities are so severe that business at that particular tenant space cannot be sustained. So they have so many turnovers of business owners. So this particular tenant complain that they cannot sustain their business. I strongly feel that security guards should be required during entire operating hours. And also, currently, the business operator has 2 security guard. I believe on the weekends, one at 9 p.m. and the second security guard comes at around 10 p.m. So actually, he's asking the less number of security guard than what he has now. Staff recommends the denial of the appeal based on the findings I made in my determination, except for condition number 28, as I previously mentioned, that is for indemnification condition. This case is a little different from other entitlement applications. Indemnification may not be really appropriate for this type of revocation cases, so staff recommending to delete condition number 28.
Okay, that's in your summary, right? Number 28 is in your summary of your report.
That is right, in my determination. Condition number 28.
Okay.
And also in condition number 1, the covenant and agreement and the plan approval application was required to be filed by property owner, but I like to include business owner and operator. So we don't care who filed the required plan approval. I like to add business owner and operator into condition number 1.
Okay, so that's another addition. Okay.
The LAPD Harbor Vice Unit was going to come today to testify, but they were not able to make it for hearing tonight. So
Okay.
I'll be available for your questions.
Okay, we're ready to go. So let's hear from the appellant. I believe it's Will Navis.
Good afternoon. I'm the applicant's representative. I am one of the appellants. There are actually 2 different appeals in this action. I'm representing the business owner. The business owner has no issue with any of the imposed conditions except for the 2 that have been outlined in my appeal rationale, and that is one for the designated driver program, which is really based for a restaurant type of an operation, and the second one is a security guard, as Ms. Chang had alluded to. In regards to the security guard issue, I'd like to mention to you that we have already eliminated the nuisance problems that have occurred on the property. We have showed good faith by doing that. As of the date of the revocation letter and the decision that was handed down, we've imposed several abatements to the nuisances that were occurring on the site, and they are the fact that we have eliminated the dance floor, the video and coin-operated machines, stopped the live music, reduced the sound decibels on the site, closed the rear access door to the premises, have also instituted a video surveillance system inside the premises, and the property owner has instituted a video surveillance system on the exterior of the premises. So a lot of the nuisance activities that were occurring in the past are not occurring any longer, simply because there's a lot more monitoring going on, and a lot of the activities that were occurring inside the pub are no longer there. So there's no need for those kind of activities to be occurring or those kind of people coming during those hours of operation. The pub has had security for quite some time. They've always instituted their security during the evening hours. They've been doing that ever since the beginning of their operation, and they've continued to do so. What they'd like to continue to have is one state licensed security guard from 9 p.m. until closing Friday, Saturday, and Sunday. That would be the most reliable method of having some sort of equality for the business owner, as well as not imposing such an onerous condition on him. LAPD has stated, and the ZA hearing has stated in their findings, that most of the problem activities occurred during the late evening hours and on the weekends. So it doesn't make any sense to have a security guard during other hours of operation.
I'm struggling with your request. I'm looking at this case file, and I've got issues here going back to 1996. I've got a 4-page 4 pages of incidents on this property, so I just want to put that in perspective, but thank you very much.
And we did provide a chronology showing those incidences occurring during the evening hours and on the weekend.
Thank you very much. And I believe we have the operator also appealing this, and that would be Vincent J. Comparsi. Any other appellants? Sir?
I'm Vincent J. Comparsi. You just stated something about 1996.
Right.
Okay. You are aware the establishment that I own and run up there commenced in 1998. That had to be prior ownership.
Right. I'm just saying the extent of this file, and how far back it goes. That was my point.
Okay, I'm sorry, then I misunderstood you. One thing I want to make clear with regards to the statement about security, it was brought up by the lady who spoke before Mr. Navis that we had 2 security guards in the evening. We've always only had 1, and predicated basically on the fact of that business activity, because in this type of establishment that we run, about 1/4 of the business transpires in the AM hours, and about 3/4 of it transpires PM and primarily on the weekend activity. So I just want to make that clear. That's why we figure that the quickest way to solve the nuisance that had existed, going along and agreeing with what the police department said in the summary that's probably in front of you, the majority of the problems have occurred on the weekends and in the PM hours. Basically, and I'll make one other statement. I know you folks are busy and got a lot of things to do. The statement that to ask for security at the pub itself would not be onerous, predicated on having a licensed security there at $18 an hour, 90 hours a week, would create a activity of taking approximately 20, predicated on the year 2009, would take approximately 28% of the gross revenue of the operating establishment based upon reported figures to the State Franchise Tax Board based on business done at the bar. So I just want to make that clear. It would definitely be onerous in asking for approximately 28 to 30% of the gross income of the establishment. Thank you.
Thank you, sir. We have John Wilson. And then we have John Mirassol.
Yes, I'm the co-owner with Mr. Comparsi. I'd like to address the problem with litter and debris on the outside of the building. We also have other establishments there that serve food to go. I've noticed many times in the morning there's food containers, wrappers, and so on. There's also a veterinary clinic there. I've seen animals on a leash, but the people would let them defecate in areas on the sidewalk and so on. I have maintenance there from 8 o'clock in the morning to 2 o'clock in the afternoon. He comes in 8 o'clock and he cleans the adjoining area on the outside. I believe the shopping center also has a cleanup, but I think they come during the night. I'm not sure of that. As far as the back door was open, my maintenance man is continuously going in and out through the back alley to the trash containers and so on and moving stock around. We did put a self-closing door closure on there. We did all the signage that was required, and our only question is the security for 90 hours a week. It would be a drain on our total business operation. But we have addressed the other problems. Thank you.
Thank you, sir. John Mirasosa, I apologize. I was trying to sound it out.
Nobody gets it right.
Okay.
Excuse me. Thank you, committee. My name's John Mirasu.
Mirasu, there you go.
And I represent the owners. We agree with all the conditions. We just would not like the conditions to run with the land. And if I could read a statement here. Since the imposition of the condition by the zoning commissioner on August 13th, 2009, the following events have occurred. The landlord, Harbor Village, served the tenant, Compai Inc., with a 30-day notice of termination of the tenancy. The tenant was served with the notice on September 5th and was given until November 1st, 2009 to vacate the premises. The landlord is preparing a complaint, Compai Inc. has not complied with the notice and remains on the premises. The landlord is preparing a complaint in unlawful detainer to recover possession of the premises. It should be prepared within the next few days and will be immediately filed and served on the tenant. Compai Inc., and that's C-O-M-P-Y, they're the owners, Compai Inc., has prepared, filed, and served a complaint for damages and for injunctions seeking to prevent the landlord from pursuing the unlawful detainer action. Since August 13, 2009, the landlord has installed a surveillance system with 12 cameras at the cost of $20,000. Within the past few days, the surveillance cameras have picked up the following activity. Not past few days, but this was written for the original date of the hearing, past month or so. On October 22nd, a patron of the village pub mugged a woman in the adjoining store. The video surveillance cameras captured this, and the owners submitted the tape to the police department. On Halloween, 5 police cars came to the village pub searching for guns and patted down the customers. Harbor Village, the owners, have installed a small park in the parking lot for the patrons to smoke so that they won't smoke in front of the other tenants. The owners of the bar have not instructed the patrons to use the park. If I may continue.
Okay, well, please finish.
Okay. And have not installed no smoking signs. The patrons of the bar continue to smoke on the steps of the adjoining tenants. And from what we can tell, the owners of the bar have done nothing to help to move the patrons from smoking anywhere else.
So, just to cut to the chase, you do agree with the conditions except for one, which limits it to the tenant but not with the land. Is that what you're saying?
Well, no, what we would like the wording to say is that the conditions will run until the tenant is no longer there, because we have no intention of putting another bar there. So if there's some wording that we can put in, if the same type of establishment is placed there at the property, the conditions will remain. But if not, then they will cease to exist.
What's your relationship again, to be clear?
I represent the owners.
The owners?
Property owners, yes.
Where this establishment is located?
Yeah, I'm sorry, the landlord.
Okay.
So we just don't want the conditions to run with the land, because we feel when we put in some other store in there that we're going to be back in front of you saying, hey, can we have these conditions removed? So as soon as we put in another tenant, we just like the conditions removed.
Okay. Well, I'll be asking the council office of their opinion on that.
Thank you.
Okay, thank you very much. Our last speaker happens to be Frank Henry from the council office. Mr. Henry, how do you feel about the request? What is your perspective on that?
Actually, my name is Frank, last name Hong, with the office of Councilman Janice Han.
We have Frank Henry right here.
Yeah, sorry.
Now you're all confusing
writing.
All right.
Basically, the councilwoman's desire in this case is to have this committee uphold the determination made by the zoning administrator. As mentioned by the zoning administrator, we still continue to receive complaints from the adjacent businesses that the business is causing a nuisance to these other businesses. In some cases, there has been harassment. It hasn't been a very pleasant environment that this business is creating. I've also spoken with John as well and understand his concerns, but it's the council's position that we have no guarantee that a bar may not go in afterwards. We believe if there is a bar, it's the clientele that will still come back there, cause a lot of the troubles that we are having now. So we are asking for the conditions as requested by or determined by the zoning administrator to stick.
So you fully support
Correct.
the report as written?
Yeah, unfortunately, LAPD cannot be here today due to the change of schedule, but we had met with them. We talked about every condition, and LAPD also upholds these conditions. They had mentioned that following the the initial hearing, LAPD has been out there, has on numerous occasions had some issues out there, so they're in favor.
All right,
of
Frank, so for the record, give me your complete name.
Frank, last name Hong, H-O-N-G. Thank you.
Okay, thank you, Frank.
Frank, I have a question, Hong, on the ABC. Is this a bar for full beverage service or beer and wine only, or is it a full bar service?
I believe this was a bar.
Full bar service?
Yes.
And while these conditions are imposed, the representative from the property owner indicates that once this establishment leaves, they don't wish to have a bar back at that location.
Correct.
The council office should discuss surrender of the ABC license regarding that property if they don't wish to have another bar at that location.
Will do.
Okay.
All right. Thank you very much.
Okay.
Okay, I want to thank Ms. Chan for her work and Mr. Hong. And I'd like to submit to the committee that we deny the appeal filed by Deborah Kahlo, Harbor Village, and Vincent Comparsi, and thereby sustain the decision of the zoning administrator in finding that the operation of the business as the village pub, cocktail lounge bar located at 2442 Southwestern Avenue has resulted in a public nuisance and requires modification of its operation to mitigate adverse impacts on the surrounding area. You have a second on that? Second. That'll be action of this committee. Next, Roberto?
Yes, council members, the next item is item 14. It's an appeal by Rex Frankel. He's appealing the action of the City Planning Commission, which approved a vesting tract map for 325 apartment units in CD 11.
Is this the last item?
Yes, council.
Okay.
Good afternoon, Maya Zaitsevsky, Planning. I was the advisory agency on the original approval. I approved it on June 12, 2009, vesting tentative tract 70318 to permit a two-lot subdivision to build the construction of 325-unit apartment building and a 225-unit condominium building. These two lots are two of the four remaining lots to be developed in the Howard Hughes Center. The approval was appealed to the City Planning Commission on the grounds that the environmental document prepared for the project was inadequate, that the 268-foot high condominium tower and the 135-foot apartment building are too tall and would result in new environmental impacts that were not analyzed in the previous EIR for the project. CPC heard the appeal and denied it and upheld my decision. The applicant is here appealing it to City Council now on the same grounds. And one of additional concerns is that he feels that actions have happened by the city over the past. This has been like a 20-year development project, and that everything has not been done with full CEQA review or full public disclosure, and so he's taking offense to previous actions that
So the CPC denied the appeal?
Yeah, and I'm recommending that you uphold their denial of it.
Okay.
Thank you.
Okay. So let's hear from the appellant. Is the appellant here?
Yes, what time limit do I have?
Well, try to get to your point as quick as possible.
Great, okay. Okay, I'm Rex Franco. I'm a resident of the affected community to the south of this project. This project is kind of a unique site that has a development agreement that locks in a specific amount of entitlement. Then it has two additional limits. One is the floor area ratio of 3-to-1 on each property, and then there's the FAA height limit to protect air travelers to prevent having buildings get too close to airplanes. These are cumulative limits that reduce the development agreement's entitlement below what the developer is seeking today in their mitigated negative declaration. What effectively happens here is that the developer is seeking to transfer entitlement from lots of, there are 4 parcels in this project that are remaining unbuilt, 2 of which have height limits that prevent them from building a great deal of the entitlement that they have in the development agreement. So what they're trying to do is transfer that to other lots and creates the highest tower in the project. What that means is that it'll enable parcels that are allowed to build to 3 times the square footage of the lot. One of them will be 5.5 times the square footage of the lot. And as a public policy perspective, the couple of the items before you had a project that was 5.5 was the zoning, and they're only building to 3.3. At the Hughes Center, they've got a limit of 3 to 1 on the property, and they want to build 5.5, but they're offering no parks, they're offering no affordable housing, and so you have to wonder, what is this landowner offering to the public in exchange? And in fact, they're giving nothing. They're actually getting an incredible windfall. But in legal terms, the mitigative negative declaration has a severe deficiency in that it claims that the action today causes no new environmental impacts. And the packet that I handed you today, if you turn to about 4 or 5 pages into it, it shows what are the developers' before and after pictures. In 1999, what happened was that the land, which was limited to 3 to 1 zoning, the landowner got the city planning department to write a clarification letter, which enabled them to shift the right to build a high-rise to another location. The before and after pictures that they show here, and there's about 4 before and after pictures, the problem is that they're not before and after pictures. They're basically after and after pictures. And the point is that in 1999, the landowner did not have the right to build a 5.5 floor area ratio building. They had the right to only build a 3 to 1 floor area ratio building where they want to put the 18-story tower. So the point is, when the mitigated negative declaration says the action today will not result in any new environmental impacts, that's not true. It's actually making it possible to go from a 3 to 1 to a 5.5 to 1 using square footage that cannot be used anywhere else in the project because of the additional set of limits, the FAR limits and the FAA limits. The point is that when you have a significant height increase on a building in an area that's been considered visually significant, basically the EIR from 25 years ago that affects this project declared all the buildings on the project would have a significant visual impact, and there's a scenic vista that will be blocked by this row of high-rises. The point here is that if you add a high-rise to an area that's already an impacted scenic vista, under CEQA you have to do an environmental impact report. You can't do a mitigated negative declaration. So
I really need you to conclude.
My conclusion is that an EIR is the only appropriate way to consider this project, and a mitigated negative declaration is illegal and does not consider the impacts that are obviously occurring with the approval that you're being requested today. Thank you.
Thank you, sir. Okay. So we have several speaker cards here. I'm assuming the applicant is here as well. Please.
Alan Apshes, representing the applicant, Equity Office Properties. We thought we might have had a PowerPoint, but we don't. I have handouts for you instead.
Okay.
So I hand them.
Okay, we are struggling here. You know that. It's 4:30. It's the last
I know,
item.
it's a long,
it's a
I know it's been a
marathon
long day
session.
for you. It started at the funeral.
Can you just get to the point? We would appreciate it.
Let me try to straighten it out. This is a project that implements the development agreement with the City of Los Angeles. We obviously have a different view of the facts from Mr. Frankel. The City Planning Commission rejected his views of the facts, as did the advisory agency. What's before you today, I've tabbed this to get you to the relevant pages. These are the final 4 lots at Howard U Center. This is a project that was approved by the City Council under a development agreement in 1986 and again in 2005. Mr. Zine, you might remember because you were there and voted for the last amendment of the development agreement. The number 1 tab shows you the aerial with the 4 undeveloped lots, with the 2 lots that are before you today in the tract. There have been multiple environmental reviews of this project, 2 full EIRs, an addendum in 2005 when the development agreement was last amended, and another MND for this project. And there have been many public benefits of this project. The public benefits were negotiated and into the development agreement in 1986, and Howard U Center has delivered all of them, including massive freeway improvements, a 2-acre public park, which is part of this center.
Can you just address his assertion?
Yeah, sure. If you will turn to tab 2, you'll see that in 1986, the City Council approved overriding considerations acknowledging that views over the center were going to be blocked because high-rise buildings were going to be built there. The building that, if you turn to tab 3, the building that Mr. Frankel is complaining about, he says it's getting bigger, but that's not the case. The original position on tab 3 shows that building in yellow. That's where it originally was, and the orange shows it where it was moved to. The move occurred in 1992. I think Maya Zajewski has that documentation. And the building has gotten smaller, it has gotten lower, and it is now farther away from the neighborhood. So the city, in fact, did some view simulation from surrounding streets. That's tab 4. And it showed that the repositioning of this building was not resulting in new impacts. It's actually opening up views between buildings. And also, because Mr. Frankel claimed that views were being blocked from his house, there was a simulation done of a view from his house. The view he submitted was from the roof of his house. That's not really a view that's available to anyone. And if you look at tab 7, there's a comparison. Tab 7 shows you from the perspective of in front of Mr. Frankel's house what the development approved by the City Council in 1986 would have looked like, and then on the right, that's on the left, and on the right is what it will look like as it's actually been built out. In other words, it's far less than was ever anticipated by the city. In other words, since it's far less, there's no need for a new EIR, and that was the conclusion of the advisory agency, conclusion of the Planning Commission. We respectfully request you uphold it.
So instead of 300 or 326, you're saying it's 268?
268. The neighborhood council, which endorsed the project, asked that we lower the building. We agreed to do that. And it's also smaller.
And then it moved to the right.
And it moved further towards the freeway. That's the 405 freeway, Councilman Zine. It moved further towards the freeway, about 100 feet. But that move occurred 18 years ago.
Now, the 326, is that an existing or was that a proposed?
That was approved by the City Council in 1986. That's the height above sea level. That's not the actual height of the building. It's
Is there anything there now?
No, it's an empty lot.
Okay, so that was the proposed, and then now you're saying it's the one on the right, the 268?
268,
okay.
That's correct.
Thank you.
Thank you.
Thank you, sir. We have Christina.
I got another question
Another
for you.
question?
The $22 million.
Yes.
What was that? What were the improvements on that?
There was a complete, basically, freeway interchange built adjacent to the Howard Youth Center. I'm sure you're familiar with it. It connects the Westchester area directly to the 405, on-ramps, off-ramps, it was a very
So it didn't help the traffic from the San Fernando Valley, though?
I'm sorry.
That didn't help the traffic from the San Fernando Valley?
Didn't help the traffic in your district.
You can do a double deck down the freeway now, so.
Anything will help the traffic in San Fernando Valley.
I'm being somewhat facetious, but thank you for that.
Thank you.
All right. Cristina Corrales? And I believe Nissan Armenian?
Thank you.
Okay.
My name is Cristina Corrales, and I am the Transportation Demand Program Manager for Howard Hughes Center, owned by Equity Office. I'm certified as an Employee Transportation Coordinator by the Air Quality Management District. I have worked at Howard Hughes Center for over 20 years, managing the TDM program and maintaining the Howard Hughes Center and TDM compliance successfully. I've stayed with Equity since they owned the project for the last 3 years for one reason. In the past, the present, I have seen nothing but their full commitment to traffic mitigation in the airport area. And in the future, their commitment is unquestionable, and this is why I've stayed working for them. I manage the full-time, on a full-time basis, I manage the transportation center. It's a full service center for all the commuters who need our assistance. Equity created a financial program for commuters who wish to participate in alternative modes of transportation. And Equity also believes in personal assistance, and this is why we manage the transportation demand program on a full-time basis, and it has been very successful. Equity has also created a transportation management association for the area. They are not just concerned with traffic at Howard Hughes Center, but also the traffic that goes along from El Segundo through the airport, through Howard Hughes Center into Culver City and into Playa Vista. We created a transportation program where all employee transportation coordinators from the area, the aerospace industry, the airport, Playa Vista, collectively address traffic mitigation issues. We have won several awards from Metro for our activities at the center, but let me tell you what the real incentive is for us. When I have an employee coming to me saying, Christina, since I started taking the bus and the train from Whittier to Howard Hughes Center, a week later my wife told me, Christina, my wife says I'm a lot nicer to her since I started taking the train. So that has been really our reward. Another gentleman who lived in the valley, his health wasn't very well, but Someone in his office told me that we have a full transportation program. He came to see me. He started taking the Commuter Express from the Valley directly from Granada Hills, nonstop to Howard Hughes Center. When he found out that we had this program available, he had tears in his eyes because he said, you know what, Christina, this has been the best thing that ever happened to me. So we take one person at a time, and our effort is to really create a great and greater transportation program for not just Howard Hughes Center, but for companies around the area, aerospace industry.
Thank you for your hard work. Thank you very much. Our next speaker.
Good afternoon, Chairman and committee members. My name is Nazan Armenian. I'm a consultant for community outreach for Equity Office Properties and work with Consensus Inc. I'm here to submit testimony on behalf of 3 speakers who represent prominent community organizations in Westchester and who have endorsed the Howard Hughes Center project. They wanted to be here today but could not be here, so they have provided video testimony, which I submit to you.
So the groups you have on your card: Westchester Planning Council.
So Steve Donnell, Chair of the Neighborhood Council of Westchester Playa's Planning and Land Use Committee. The second one is Christina Davis, President and CEO of the LAX Coastal Area Chamber of Commerce. And John Rulin, who's a 37-year resident at Westchester. He's the Secretary of the BID and the President of the Westchester Streetscape Improvement Association. We've also submitted to the committee a book of over 100 supporters who work at the center. They are all crying out for housing opportunities there so that they don't have to commute and would like to live there.
So you are opposing the appeal?
I'm sorry?
You are opposing the appeal?
That's correct.
Okay.
Thank you.
All right. I don't know. Can I ask the staff to come on up? The structures that are being debated, are they commercial structures for office, mixed use? Is there a designation for the use?
What's before you today is a tract map with 2 residential buildings, one of which has a restaurant in the ground floor. There's 2 other buildings that are subject to a conditional use for FAR averaging that I heard as a zoning administrator. That case will go to the West LA APC. So there's 4 sites that are being constructed, but before you today is just 2 residential components. So
the request to be consistent with the priorities of the city for affordable workforce units, does that occur now?
There's no workforce housing proposed.
And if we would want to assert that request, could it be done now, or is this something we let the council office know that should be considered?
The council office is here, so you're more.
I don't think they're prepared to answer this question unless you'd like to, but when they do come up, please. Yeah. Right. Given the residential component that's being contemplated, can you give us a number of units that you are looking at?
This is conceived of as market rate housing. We're very aware, and we sat through the earlier matter in which you discussed this, the Wilshire La Brea project. This is a project which is really on a different footing in that this is a development agreement where the public benefits of the project were negotiated and set long ago, and at that time they included transportation and an open space park and various other public benefits that have been delivered to the city. So at this time, what's different about this project from the one that you were discussing earlier is that it's not seeking a new entitlement. Actually, it's seeking to utilize the rights that were granted by contract from the City of LA. So,
but you are open to that discussion.
Well, based on the current development agreement, what's before you today really is market rate housing, and we wouldn't want to mislead the committee or the council. We are under discussion with the council office about future of Howard Hughes Center and a potential development agreement extension, and in the context of that discussion, we're looking at all sorts of uses, which might include senior housing, affordable housing, other types of uses.
I understand what contracts mean.
Yes.
I understand that.
Yeah.
But I also know that Councilman Rosendahl has been a strong voice for workforce housing.
Yeah.
So you do have the discretion to revisit that contract should you choose.
And it's not our proposal to revisit the contract because the investment has been made.
No, I'm not saying that's a proposal, but
Yes.
that is an option.
To be honest with you, Councilman Reyes, it's not an option now because we're utilizing the entitlements that were granted by the development agreement. So
No, I'm saying you choose to not make it an option.
it's something we'll discuss with the council office if and when we discuss an extension of the development agreement with them.
I hope you're hearing our message.
I do hear your message.
You do have an option to open that up if you choose.
Well,
Yes, we do.
Let me chime in on this. When look at this residential component,
Yes.
Mr. Rosendahl was the one that championed the project at Willoughby and La Brea, not his district, but he championed on the floor of the council for that developer at the time we were voting to include workforce housing, and he was the champion of that. And I find it amazing that that hasn't been a consideration on this particular project. And the $22 million investment in transportation improvements was ingress and egress to that center. And I've traveled that road, I've exited, taken Sepulveda down to LAX. So that access assists folks that are going to that Howard Hughes Center. I've been there at the Nordstrom's Rack, I've been there for dining. There's folks that work at Nordstrom's Rack, there's folks that work at the restaurants, and the concept that we're trying to push is to be able to live and work in the same neighborhood so you can take a jitney or take a bus or something, and not have to travel from the San Fernando Valley so you can work in that particular area. That's been the emphasis. The other aspect is open space. Open space is going to be beneficial to the overall community and the workers at that center. If the folks aren't living there, and if there's only market rate, it's going to be exclusive to that particular neighborhood, and it's not going to extend out to the other folks. And what we're trying to do is encourage development where we have a mandate for housing, and it must be included in projects. And I don't know how Mr. Rosendahl, in good conscience, is going to support this without pushing, as he has pushed in other areas, housing for the working class of the city of Los Angeles. So maybe it slipped by, maybe he wasn't cognizant at that particular time, but he's been a champion along with Mr. Reyes. So I would say that the condition needs to be discussed with him, the condition of workforce housing. And while you may have your entitlements and all the other aspects, without workforce housing, I'm going to have a very difficult time supporting this particular request, just because we need to be consistent. We've been consistent with the other developments, and we must be consistent with this development as well. Since you have so many workers that work in that area, they should be able to live in that area and afford to live in that area, and not $1,300.50 for a 450 square foot single studio.
Let me ask the Madam Attorney. What's before us is essentially an appeal to approve a project that's being asserted as being piecemealing and splitting approvals of a huge impact project into small, non-controversial pieces. Our actions today allows them to move forward on their development, or just allows them to stage their property where they will need more approvals for their development? Can you just clarify what stage of the process they're in?
Jerry Burge, City Attorney's Office. What's before you is an appeal related to a vesting tentative tract map. And although the appeal is based on CEQA, we have always taken the position that a tract map appeal brings the entire tract map, what we call de novo, in front of you. In other words, you can amend, you can affirm, you can modify, you can reverse, you can do anything related to the tract map so long as it complies with the MAP Act and our laws. As to this particular condition, you would need to be able to show what it is about this project that requires the need for affordable housing in order to impose a condition like that, as well as look at the development agreement, which I have not done. I haven't looked at the development agreement.
I think the key word here is impose, correct?
Correct.
But they could volunteer that.
Yes, however, You've heard my lecture before. The volunteered conditions are not enforceable, and we do not recommend volunteered conditions. They're just a bad idea. They mislead the community that there's actually a condition that someone will enforce.
If they took the step to enter a development agreement that goes beyond just the lip service of a volunteer, that takes a different course, doesn't it?
That's correct.
So is that available to us if we don't act today? How much time do we have to act on this?
You could continue this, I believe, 1 week without the need for consent, because the last day is December 2nd. But, and you could do that, and we could look at the development agreement. I'm sorry, that was not before us, and I have not reviewed the development agreement. I don't know if the development agreement prevents you from what you're requesting.
Well, before I go any further in the discussion, I would like the perspective of the council office, and I hate to put her on the spot. But I know she's here today, and I'd just like to you've been listening to our conversation and get your impression.
Sure. Well, my impression, my understanding...
Introduce yourself for the record.
Whitney Blumenfeld for Councilman Bill Rosenthal's office.
What's your title at the office?
Senior Planning Deputy.
Okay.
My impression has been that the development agreement, as currently stated, did not allow us to ask for anything new. In addition, the councilman did not want to be in support of this project, as he did not feel it was though it was his project, as though it was approved in '86, way before he was here. If he had been able to change something, disapprove it, change heights, that would have been the direction he would have taken. However, we had asked the city attorney to review the development agreement in full to see if anything new had been asked for that had not been previously granted. And based on that review, that was not determined. At the same time, the Howard Hughes development has said that they're looking to possibly change future entitlements, and in that discussion would, of course, be in exchange for any new development agreement, affordable housing.
So if we held this over a week, would that put the city in a stronger position to be consistent in trying to achieve the goal of creating workforce housing units?
If we're able to ask for that, based on the city attorney, based on the fact that we're able to do that in the development agreement, then sure.
Well, the discretion here is really based on the direction of this committee, if we're going to support the appellant or not. And so the nexus here, from my point of view, is there a basis for supporting this appeal? And that's where it gets a little complicated, if you will, based on the development agreement that you already cited back in 1986. But I want to ask the representative for the development. I'm going to put you on the hot spot here, sir.
I feel like I'm on the hot spot. It's okay.
Okay.
It's all right.
But that's the nature of the beast, right?
That's my job.
About misrepresenting your client,
Right.
Are you in a position to afford this committee any indication that workforce housing could be made available on your property?
I'll tell you this, and first I'll be honest, and the development agreement precludes the city from adding any new impositions.
Okay.
Okay, I want to be straight with you. That's our client's position. We are currently under discussion with the council office about potential extensions and changes in use. And in the context of that, I can give you my commitment that we will explore additional housing, workforce housing, with the council office. In the context of this development agreement, these approvals, the appropriate thing for the committee to do is to deny the appeal and send them on, because the committee cannot legitimately impose affordable housing or any other new condition on this development.
I want to be clear for the record. I would not, put it this way, I would support the appeal based on a whole other set of reasons, setting the affordable housing aside. Because I understand what you're saying with this commitment, so I want to make that clear for the record. Because I know that could be followed up in other procedures that are legal in nature. So that I am very cognizant of your options there. But at the same time, opportunities are in front of us today. And I'm asking, as the city attorney has already indicated, a volunteer really means nothing unless it's in a written form in a development agreement. And you're saying you're not ready to do that as far as these two parcels are concerned.
I could not agree on behalf of my client to a condition requiring anything new. It would be inconsistent with our agreement with the city, but I can give you our commitment that we'll explore in good faith with the city, working towards potential options in connection with an extension of the development agreement. I think that's the appropriate thing.
Okay. Councilman. At this point, being that this is Councilman Rosenthal's district, are you comfortable with what's being said today?
Am I comfortable with what's being said? Am I comfortable in terms of there not being affordable housing? I think
Right.
is that the question?
Right.
The council member in general, no, is not comfortable with that. I believe that he did not want to support this project, and if he had asked for affordable housing, he would have been in support of the project. That would have been the reason for that. We can postpone it a week and discuss further. I can discuss this further with him.
But why don't we do that? Because I would feel it would be clear to me what our options are without violating commitments and contracts are already on record. And I respect that process. But I also know that things could change if property owners choose to go that route, and it's really up to them. So I know my staff's going to kill me, but we'll postpone this 1 week. That means we have a much longer meeting next time, Dennis.
Well, no, not really, because the matter hopefully can get resolved. Were you in council today that Mr. Rosendahl pushed for that workforce housing in
No, I
LeBray?
wasn't.
You may remind him of that. LeBray and Willoughby, on the floor of the council, he pushed for it, and then development agreement was changed before the vote was taken. I just wanted to remind him of that.
Thank you.
So we have the ability to continue this 1 week, and we will do that. Okay. Thank you very much. All right. Anything else?
Public comment, Council.
Public comment. Oh, my goodness.
Yes.
Surprise, surprise.
Surprise, surprise. Nice seeing you. But you know what? Seriously, now today was an interesting day because this voluntary condition stuff, I disagree with the city attorney on this, and hopefully the new city attorney will change the policy. Voluntary conditions are enforceable. They're enforceable under LAMC 11.0, which makes a violation of a condition of a tract map a nuisance, a technical nuisance, and it is enforceable, and I was able to get it into two Valley Village tract maps without the objection of the city attorney. But so I'm telling you, it is going to be enforceable, but that's another issue for another day. And secondly, the other things that came up today, very important, are economic feasibility. You guys don't have the data that you need. You got to draw out these developers in terms of, okay, what's it going to take to produce what needs to get produced? That will help the public. Thirdly, most importantly, and I'm sorry Mr. Weezer isn't here, but the lawsuit over the SB 1818 is over. You're going to have to produce a couple of new ordinance that's going to take out the offending portions as per the court. I'm asking, as part of that we get the data that was in Mr. Weezer's motion. He made it in April. And it was part of the original directive from the Council of the Planning Department that said, we want to get the data on these SB 1818 projects. How much affordable housing are we destroying before we create it? I need you to do that. I need you basically, if you can just put that motion on the calendar at some point, we can have a discussion on it because and Gail Goldberg says, look I can't get the economic data from these people because they won't get it. We can get a dialogue on, Mr. Reyes, between the communities and the developers and the public and the neighborhood council so that when you get to the point of having these decisions, just let me finish, Mr. Zion, then you can talk.
I'm just counting down the clock.
Well, I know. But seriously, but you know what? You say you're for affordable housing. I'm offering you options and alternatives in terms of how to get it. And you know what? For 20 seconds, you can listen, respectfully. Okay, so the bottom line is, what I'm saying is we need the data. You need the data. What Mr. Weezer's greatest moment was, does the city have an affordable housing policy? They don't. We need to get to that point. I'm asking you to help us do that by setting that motion. Thank you.
Thank you, Mr.
Anyway,
Watts.
thank you for listening.
Anyone else want to comment? Seeing none, this meeting is adjourned.